Would please take a seat. I'm going to call the meeting to order today, Monday, March 19th. So could you please call the roll?
Yes, Ms. Steinkamp.
Here.
Mr. Sims.
Here.
Mr. Little.
Here.
Mr. McMillan.
Here.
We've got new board member Darlene Jacobs, who I'm assuming is just running a little late. Mr. Brister.
Here.
Mr. Bordelon.
Here.
You have a quorum.
We went over this last time. If I have to have a motion from the floor to plug this in, I'm on seat one.
I'm sorry, I didn't hear what you said.
He's informed me that I cannot plug this in.
Right, and you have to have a seat.
Well, I pulled a seat over here.
Okay, well, have a seat.
Well,
Can you plug
about
it
the
in?
issue plugging in, he said I can't plug this in.
That's correct.
I can't get a motion to plug it in. I thought Mr. Howard told last time this was supposed to not be a big issue.
Okay. We're going to go
I'm
forward.
asking if there's a movement from the floor for me to plug this in. I don't mind moving a seat over here. That's no problem.
And I would just ask the president, in the changing venues, or is there a reason why that we just decided not that he could do that?
Well,
It's still a meeting rule, and y'all adopted it as a meeting rule, not as a facility rule. So that's up to the board, whatever y'all want to do.
How do
But,
we get it on the agenda to change the rule?
yeah, we'd have to.
No, the rule clearly said the board would have to specifically exempt. I specifically got that wording in there, so y'all have to make a motion to exempt.
Robert, please. All right.
I'd ask the attorney on opinion on that, because I have no problem with him having it in there. I could make a motion that liable to fail for lack of a second, but.
Well, that's what I'm saying, is the board, yes, the board can, if he makes an application for a waiver, you obviously can make that, decision as a board, and you would have to do a motion.
Okay, but are you telling me at this meeting it can't be done?
It's a meeting rule, that's what I'm saying, is I understood it from y'all. It was a meeting rule, not
I'm
a
reading them
rule.
right now to see if it said that it could be, how I'm looking at it. The taping and otherwise needing for power for equipment must provide their own source of electricity. No electrical cords are allowed.
Children on a NAT.
You can make a motion.
I mean, it's up to you.
I'll make a motion to
Can we do that?
let him be able to plug in, to exempt that meeting rule, that if we have somebody that wants to videotape and they need a battery accessibility or a plug-in, that we let them plug into an outlet if we have an outlet available, as long as it's not against the meeting room folks. That's a motion.
Do you have a second?
I got a question.
I'm sorry,
We
there's
have to have
no
a second.
second. You may not discuss it. Freddie, please sit
Well, I
down.
stood up to be recognized.
Okay. I recognize you, but I can't recognize you on this point because I do not have a second. I can't recognize you
Thank you,
either,
Well,
Robert,
I'm gonna
because
make
I don't
one
have a
quick statement.
second. No, you're not,
Yes, I am.
Robert.
No.
I'll shut it down, and I will have each of you served with an open meeting violation. That's all there is to it.
Okay, motion failed.
You have unreasonably restricted my
Robert.
ability to see this.
Robert,
I'm leaving. I'm going.
okay. So we are anticipating Darlene will come, is going to show up. She said she would, hopefully. She's just running a few minutes late. Okay, approval of minutes from January 23rd, 2012. Do I have a motion to approve the minutes?
So moved. I second it.
Have a first and a second. Freddie, you have a comment
Yes, I
you
have
want to
a
make?
question. Last meeting, I asked specifically concerning going to executive session, and I was told by Ms. Dow that she was in compliance. Since then, I have a report from the Attorney General's office, Ms. Moore, stating that Ms. Dow violated 42.
That's not what she says. That is not true. I have gone over with her. We listed an incorrect statement as far as the reason for it. It should have been A10 when we went in to discuss the legislative auditor's report, and we listed it at A1. So we have corrected that, so that's taken care of.
Correct, but I was not made aware of it, and nor was I given correct information when I asked.
When did you ask?
I asked who and why were we going in on what purpose?
Under A10, and under the laws regarding legislative auditor's report, we could not talk about it, and that's why it was stopped. I have discussed that with Ms. Boyce, and she has advised me I was in compliance for that reason.
She said you were in compliance?
Yes.
Well, here she writes that you were notified, and you said that you would not
Yes, she asked me to correct it, and I have taken those steps and advised the board of those reasons.
Okay, well, because I mean, you told me blatantly I was wrong.
I don't remember discussing this with you at all,
Yes, I asked specifically for those details, and you told me you were in compliance with the statute.
and I am, according to Ms. Boyce.
You read the wrong statute, correct?
I read the wrong section of the statute.
Okay, so are those reflections going to be corrected in the
Yes.
minutes before they're approved?
Yes, we probably should correct those. Thank you.
Well, thanks, Freddie. That's good. So we'll,
Yeah, it was A10, not A4.
Okay.
I
And the
mean,
minutes-
A1, excuse me.
The minutes only don't,
say
quote the
18.
statute.
Okay.
But it should have been A10.
The motion is to enter into executive session to discuss threat of potential litigation.
Yeah, it should have been A10, other matters as provided for, not, by the legislature.
Okay, so those will be revised and brought back
Yes.
up at the next meeting.
Yes.
So do we need to put that in our motion, or we can just
Yeah, you
approve
should-
them?
yeah, you should-
Okay,
you
so
should.
whoever made the motion, would you like to stipulate that we make that change?
Those who moved and
I
seconded.
moved to amend the minutes to show the approved language of whatever law statute that pertains to that section of the minutes.
Do you have a second?
I second.
All in favor?
Aye.
Opposed? The ayes have it. Okay, and I was remiss in telling everybody about this. This is our new timer that you will, for the public speaking, it's 3 minutes. When the yellow light comes on, then you have 30 seconds left. So that will,
And what's the, well, you're making a statement, so I'm just trying to make sure it's clear. Is that per item?
yes,
Yes.
And
Per
what
item.
about the yielding of the public to their time? Because that's also permitted.
I'm sorry?
The public, someone else who wants to speak, yield their time to me.
Each individual can have time,
Correct. but
the same amount of time.
Correct. So if they yield their time to me, I can continue on for another 3 minutes.
no.
No.
Yes.
That would be up
No.
to the board.
No,
That would be
that
up to the
has to
board.
be
No.
procedurals because it's done in legislative bodies all the time.
Okay.
As long as someone yields their time. then
We're
I
not
have the
under,
right.
we're not under legislative rules, we're under Robert's rules.
Well, that's the same thing.
No, it's not.
So you telling me that no one in the public can yield their time, that I continue on with my own?
Nope.
Yes.
That's what you're saying?
Yes, that's what we're saying.
That the board reflects that in the records, that no one's
Okay.
permissible.
Okay, thank you, Friday, we'll do that. All right. So, old business, we have approval of tested applicants.
Yes, our applicants, we have applicants 1 through 6, everything is in order, and they've all tested and passed their examination. Applicants 7 and 8 are both pending bonds at this moment.
And so should we take 1 through 6 together? Every single thing's in motion?
We could.
Just-
I wonder if this is Darlene
I move on
calling us.
Try
1
it,
through
take it.
6, that we go ahead and
This
approve
is
the
Sandy?
applications.
I second.
I have
Yes.
a first and a second that we approve 1 through 6,
Okay, hold.
since everything's in
Hold on
order.
1 second. Can we possibly get our new board member directions on how to do this?
Okay,
No discussion.
I
No
had a
discussion.
question. I couldn't hear.
I know, it was a little distracting. I'm going to repeat it. We've had a first and a second that we approve the tested applicants 1 through 6.
Who was the first and the second? I'm sorry, I was on the phone.
Who's
I made the motion.
And Lamar second.
second?
Thank you.
And if we could read into the record the names of 1 through 6, just for the record.
Charles Lines, Todd Utpadel, Selena Skiles, Roland Alford, James Bennett, and Jarrett Fairman.
Oh, you got a different agenda.
I do.
That's what I got.
That's what
Yeah.
I got.
So we all have.
Okay, because James Bennett is pending his bond still.
Okay, so then we need to
that's why,
switch that.
yeah.
Well, you said 1 through 6.
Sorry. Okay, then I have a different agenda. Sorry. It's Joel Randolph and James Bennett are pending their bonds.
So 5 and 6 are pending?
Excuse me.
No.
5 and 8.
I'm sorry.
5
1
and 8.
second.
Can't hear.
All right, just read the ones that are,
Okay, let's start
Charles
this over.
Lines, Todd Uptable, Selena Skiles, Roland Alford, Jarrett Fairman, and Stephen Lowe.
okay, so we
Everything
need
is
to
in order and they've tested.
Okay, we need to amend the motion.
I make the motion that the ones so read, go ahead and test and approve applicants.
Okay, do I have a second?
I'll second.
I have a first and a second.
I only have one question, Madam Chairman.
You have a question about that?
Concerning the apprentice, Selena Styles, who did she apprentice under?
Deborah Johnson.
Deborah Johnson.
Turned it on. Any other questions, Freddie?
Yes, ma'am. I'm just making a note right quick. And Ms. Johnson verified all the information, the number of auctions and things like that. How does the board go about
On board 3.
determining whether or not an individual has gone through the process correctly?
Ms. Skiles submitted a completed apprentice application, including her completion sheets.
Completion sheets with the auction dates to coincide with anything to verify the auction did take place.
That's what I said. She submitted her completed sheets.
Okay, so you're talking about the back to me. It's hard for me to hear.
Yes, everything was submitted and everything was completed and everything is in order.
Okay, we may need to get some type of PA or something, because I mean, it's hard to hear it.
Okay, any other questions?
How about if they address the board, they just, for today?
You're welcome to stand at the podium when you address. No, you asked if that's why it was here, and no, that's not why it is here, but you're welcome to do that when you have a question.
Just go right there.
Okay, all right, that'll work. Thank you very much.
Okay, you're finished? Robert, you have a question about the applicants?
No, is this meeting being audio taped?
Yes.
It is being audio taped?
Yes.
By the board? Okay.
Yes. Okay. So I have a first and a second. All in favor, say aye.
Aye.
Opposed? The ayes have it.
I'd like to
Okay.
move on James Bennett and Joel Randolph pending bond. I'd like to make a motion that once we get to bond, these applicants be approved.
So I have a second?
So moved.
I have a first and a second. All in favor?
Aye.
Opposed? Ayes have it. Okay, number 2, approval of auction business applicants. Everybody's in order. We have 3.
Everybody's in order.
Has everything: Surplus Asset Management, the Felicia Bargain Store, and D&N Auction. Everything's completed. Do I
Yes.
have a motion to approve?
So moved.
Have a first and a second. Any discussion? All in favor?
Aye.
Opposed? The ayes have it. All right, number 3, approval of reciprocal auction business. Kurt's Auction and Realty Company. Is
Everything's in order.
Where they
everything's in
from?
order.
I'm sorry.
Please turn off your phones in the meeting, or stop, put them on silent. That's okay.
They are from Kentucky.
I move that the Kurt's Auction and Realty Company be approved.
Have a second?
I'll second.
Any discussion?
Yes, ma'am.
Let me see the phone.
Curtis, everything in place?
That's what we just said, Freddie.
Okay, I'm asking a question for the record.
Right,
So. you
and
tell
I'm
me in
answering.
place.
Yes.
Okay, because I have an article here where they made advertisement. Anybody aware of that? Thank you very much.
You have the timer going?
They were issued a temporary license.
You have the timer going?
Yes,
Yeah.
Hmm?
Okay, I'm questioning an ad violation here of Hertz Auction prior to making an application.
Okay, so they not have their license number on there?
They're advertising that's an auction being held here.
Do they have a number on there?
No, they don't have the business number here at all.
Do they have an individual auctioneer's license number on it?
It does show an individual auctioneer's
then it's
license
legal.
number, but that
And
doesn't-
we actually, Friday, they had a temporary license to do that.
Okay, and when is that temporary license issued?
The date on the letter.
March 2nd.
So March 2nd, they published, they got a temporary, and that was granted by you?
Yes.
And so the board has the authority to grant temporary license to businesses?
Yes.
And when was that instituted?
I don't know.
I think y'all talked about it last
Last
meeting.
meeting.
Well, the records speak that I know the board did not. They talked about auctioneers.
Who
not
is the
auction
individual
business.
auctioneer, Freddie?
But
Who is the individual auctioneer, Freddie?
It's irrelevant.
No, it's not irrelevant.
It's not.
It's not
It's an
irrelevant.
auction business. And that's what I'm
I'm
questioning.
not gonna argue the point.
What's the
Freddie.
date of that sale?
The date of the sale is on March 30th. whatever.
Well, then
All right,
these,
let's just let him finish
But
his 3
let's go,
minutes.
let's stay
Okay.
on record, because I have no time.
Right.
I'm telling you now, each time you ask me something, he needs to reset the
we're
time.
not gonna reset anything.
You're not?
Now, you heard.
Okay, all right, Freddie, let's stick to the topic. Okay, so do you have any other
Well, no,
points
I'm
about
waiting on you to
this?
answer me. I just asked you a question.
We don't have to answer you, Freddie.
Oh, you don't?
No.
So you telling me that this board can,
We answered you, and it wasn't sufficient, so
No,
that's
ma'am.
all we can do.
no, I asked you, when did the board approve that? And that's what I'm waiting on you to answer.
We approved the individual license
Right.
last meeting.
I know.
Then he came back and discovered he had to have
Correct.
from what I understand, a business license. He has applied for it.
Yes, he is, and we're
So, I
approving
mean,
him right
it was
now, right?
approved as an individual.
Right, correct.
And then he did not realize he needed a business
Right.
license, and he came back and put in for it.
Yeah.
I'll say, so the auctioneer's license number that's on here is the auctioneer's business license that's being approved here? That's what you're telling me, James?
No, it's not.
No, it's his individual license, Freddie, which the board approved to issue. The man, anybody that's reciprocatory can get a license.
Well, it doesn't have a reciprocal license.
Time's up.
No, my time is not up.
No, it's 3.
My time is not up. I'm answering questions at the same time and not giving us a consistent amount of time to speak. And that's what I said. Whenever you do that, you need to readjust that clock.
Freddie,
Because you asked me
we issued him a temporary license pending his paperwork and bond individually from a reciprocity state. He did not realize he needed, under Louisiana law, a business license, which he immediately reapplied for, and
Why would he need a temporary license if he's a recipient?
Yeah.
That's the
All right,
question.
okay, we're gonna move, I'm sorry, you're not recognized. I know, I'm gonna recognize everybody one at a time. All right, Freddie, your time's up. Thank you very much for your
My time is
comment.
not up.
No, I'm telling you, your time's up.
I hadn't spoke 3 minutes. You all have asked several questions, and I have not consistently been able, my point is one point only. And that's what I should be talking about, not any other questions, and I'm asking direct questions. Now, you're gonna have to adjust that, and y'all gonna have to do something about that, because in any legislative body, any order of a meeting, when I'm specifically talking about one issue, that's the issue that we wanna talk about.
Okay,
So
Thank you,
you're
Freddie.
asking me other questions. I asked, when did the board approve this, and why would he need a reciprocal
we
temporary
have to-
license? Why would he need one when he's in a reciprocal state?
I do agree with some of the things that you're saying, because we do that in our parish meeting. But when you're on one order of business, and you get up to speak about that, and you have your 3 minutes time, and the board members speak to you, then that time is deducted in our meetings, and I wouldn't have any problem with that doing it here. But you had dialogue on a lot of other issues other than that one issue, back and forth, with like giving me names, giving me stuff like this. So if you're gonna stay on point,
That's
then we
what I
need
was-
to stay on point.
Correct. I would see
Okay?
that.
And I think we've given you that extra minute of dialogue kind of between it, but we've got to come up with some kind of rules that give you an opportunity to speak from a public standpoint. But I've never been in a meeting where the audience has had open debate with the board. If we do not have open debate, you can get up and state your point,
right.
And that's what I
hold
was
that
saying.
point, but then you want to debate with this group?
No, I
There's
wasn't.
One at
no
a time,
reason
Freddie.
that a audience member debates this board's business. State your point, we address your point. When your time's up, you sit down. If you feel like you get extra time, then we'll give you
I
extra
see you, Sharon.
time during discussion. But I can tell you, I don't agree with you arguing back and forth with this board, anybody
Well, I
at
wasn't
any
arguing
point in
at all.
time.
Freddie, let him finish, and then,
But I wasn't arguing. He
What?
makes a statement.
you're arguing right
You
now.
wouldn't give Mr. Sims, he asked you a point-blank question
But I was
3
talking to
times.
the chairperson.
What, Mr. Sims, as a board member, asked you a
But-
point-blank question.
but he
Let me
didn't
finish,
Freddie,
Fred.
let him fit, Freddie, well then
Yeah,
Freddie,
I-
have a seat.
No, I'm not gonna have it.
Where's the
Put me
guard?
out. If that's what you
Come
want
on.
I
to
have
do.
the floor.
We are.
But I'm just saying, she never recognized
But
it.
I have the floor.
But
He
she
can ask a
recognized
question.
you.
Okay, then when somebody asks you a point-blank question, you've got to be able to talk.
Well, I asked the question, and I'm
If you
specific
wouldn't
about
answer a
Kurt's
board
argument.
member.
And that was it.
You
That's
should
all I
answer a board
asked.
member.
So if you want to escort me out, that's no problem.
Freddie, unless you can
Look,
calm yourself and have a seat
Calm
and be
myself
quiet.
to what? I didn't raise my voice in here.
Freddie, you're a little bit out of control here. If you would like to be calm and have a seat, you're welcome to stay.
Call
But
a
if you want to
question.
stay, All outraged, you may not. Yes, Sherry, I do see you. I'm going to go to the board first, and then I'll let you have your comment. Yes, Jim.
We approved anybody in a reciprocity state can get an individual license at the last meeting. Am I correct?
Yes.
Okay. Under Louisiana law, Anna, individual auctioneer that owns an auction firm in an out-of-state situation must have a Louisiana business license. Is that correct?
Depending on what the other, reciprocal state has in place. In some cases, we must comply with, we have the same rules that they do.
Okay. So he was issued a temporary license as an individual auctioneer, correct?
That's correct.
And his advertisement should reflect such, correct?
Right.
It does not have to show a business license until whatever does it.
To be honest with you, I think you have that on the agenda today to actually discuss that issue. You may want to discuss it at that time.
Okay, let's do
but,
that.
But right now, as it stands, reciprocity, individual license, correct?
Yes.
Okay, I move he receive his license.
Second. Don't have a second on that motion.
Well, we had the first and the
Yeah,
second.
motion
That's why
second,
we were,
right.
yeah, that's why we're in discussion. And we're going to let, Sherry, you have a question for the board?
I just wanted to know what state.
You can have a comment. Would you turn the board?
I wanted to know what state the reciprocal applicant was
Kentucky.
from.
Kentucky, they said that earlier.
Okay,
Kentucky.
sorry, I didn't hear that.
And Robert, you would like to make a comment to the board?
Yeah.
What's your comment? All right, we'll start the
Since
timer.
earlier you said we.
You can make a comment, Robert.
Earlier you said we didn't realize he needed a company license. Could you clarify who we is?
I did not know the board did. To my opinion, the board didn't know at the time we did the motion to the reciprocity applicants that the business license needed to be included in the application. It's going to be today.
Is that true of all board members?
My understanding, I mean, I don't know. You have to ask them.
Do you have any comments, Robert?
Well,
I know you asked a question, nobody's answering you. Do you have any other comments on this issue?
No.
Okay, well, thank you.
No, I'm not finished.
Well, I just asked if you had any other comments on this issue and you said
I
no.
did not say no.
Did he not say no?
Because one of the advantages of videotaping, we would be able to watch.
All right, Robert, what are your comments?
The other one is this any different whatsoever in what happened with Dan Mahaney?
Any other comments?
We were certainly told, well, I keep asking questions, if I get no answer, at least there's an audio recording of it. Was he not told he had to have a company license? Was he not told that either you get a company license or you reschedule this auction? Was he not then put in a position having to pair up with Dave Gilmore, an act which ultimately cost him $34,000? That's why if we, whoever we is, aren't familiar with the rules, I think it'd be a good idea to phone up on them. And with that, I am concluded.
Thank you. Okay, so I had a first and a second. All in favor?
Aye.
Opposed? The ayes have it. Motion passed. Welcome, Ms. Jacobs.
Thank you.
How are you?
Sorry,
Welcome.
well, not too well. I had a hard time finding, nobody knew where this building was.
Oh, goodness. Okay, well, next on the agenda, approval of reinstated applicant Terry Butler.
Yes, we have Terry. He was, originally his license was issued March 28th of 2005, and he was only an auctioneer until December 31st of 2005. So he has submitted a brand new application, and he did test and pass his examination.
I make that motion.
I have a motion to approve Terry. Do I have a second?
I'll second.
Any discussion? All in favor? Opposed? Ayes have it. New business, approval of financials. Number one, do we need to approve the financials first, or can I do the capital outlay first? I guess we do the capital outlay first.
Yeah.
Okay. Number one, capital outlay. I have a motion by Mr. Sims.
Motion to set up a capital outlay fund. And I will go into specifics in discussion.
I'll second it.
I have a first and a second. Discussion?
At this present time, the Louisiana Auctioneers License Board, Robert, can you hear me?
Yes.
Okay. At the present time, the Louisiana Auctioneer's License Board has in its two bank accounts $219,222.17 in combined funds. That includes, in the main operating account, $139,625.96 and a money market account of $79,596.21. At the present time, our operating expenses are $55,000. It's on your financial report through today. With 3 months remaining to go, we show $55,327.77.
I do not have a copy of the financial report. I would like to see it.
It's right there in your paper clip.
It's
I'm
right
sorry.
here?
Yes, ma'am. The next page, it looks like.
Okay.
Right there.
I just want to let y'all know these lights ain't working on this thing. And I'm not timing you. I'm just trying to see why the lights aren't working.
Is this what she has?
$55,327.77 and divide that by 9 would give you $6,000 some odd dollars per month operating expense. And if you add that to the $55,000, you would wind up with $73,770.36 for operating expense for the current fiscal year that will end June 30th. At this time, I make a motion.
Well, your motion was made, but
No, I'm making the
Again,
motion to set the
another
fund.
motion?
I'm making the motion to set the fund, or you add it to the motion or whatever. The motion on the capital outlay was originally to read 150% of the annual operating budget be left in the account. That would be around $110,658.54. And therefore, the capital outlay account we're talking about setting up, the initial investment would be $109,566.63. My proposal is this: to put this capital budget together. Hopefully in the future, we'll be able to purchase a building for the Louisiana Auctioneers Board that we wouldn't be paying $12,000 worth of rent that we're paying today if we were paying all of the rent, which it looks like that's what we're going to wind up doing. And plus whatever insurance and upkeep we'd have, but I think it would be cheaper on this board to set this fund up. It would be also an outlay expenditure fund for equipment or whatever we needed could be tapped into for that if the budget wasn't supported. So that's what the item is for the capital outlay.
Do you really think you could purchase a building for $109,000?
We know,
Particularly Baton Rouge?
not right now, no, but in the future, we know where, I know where some property was in Baton Rouge, down in the adjacent vicinity to where the board office is now, that are around $200,000.
Do they have any office condos there for sale?
I don't know.
Because that probably would be cheaper than purchasing a building.
I mean, I
Yeah,
don't
we
know,
can
Ms.
make that
Jacobs.
decision.
I think you could
But I
probably
mean,
get
that-
an office condo in the Baton Rouge area for around $149,000.
Yes, depending on size.
Right,
Depending on
exactly.
size.
And this is not a huge board, so you don't need a lot of size.
Right.
Rather than, a capital outlay of purchasing land and then building the building, you're looking at probably $500,000 minimum.
So the motion is to set the capital outlay budget, and we can decide later what we're going to do.
Correct.
I would second that.
Correct.
any other discussion?
Yeah, just
Hal?
in that, and maybe appoint a committee to get back to this board on the,
Yeah.
you know, getting some numbers, like Elaine was saying, looking at some properties to give us an idea of what's out there.
If y'all want an office condo, I'm very happy to have my real estate company take a look at what's available in New Orleans, in the Baton Rouge area, and give you all some comparables.
Does that sound good?
And when she says that, I just don't want any conflict of interest as far as a board member's company doing something. If it was gratis,
We would do
that
without fee. In fact, I'm serving on the board without fee. So
Thank you.
that's not a problem for us.
Okay.
good. I just didn't want us crossing.
And no, she can provide information, that's,
Right.
that's
We're
not an issue.
providing information.
Right,
What area
exactly.
do y'all want to be?
How about across the bridge?
Someplace that's easy to find, right?
We're located right now on Sherwood Forest Boulevard, which is right adjacent to the Whitney Bank,
I know what
Yeah.
or it should be Hancock Bank, I guess.
No, it's
No,
Whitney.
in Louisiana, it's
And it's a
San Whitney.
convenient little,
No,
it's a
everything's
But
convenient
it's
area.
pretty convenient,
It's very
Darlene, it's
convenient.
easy to
That- and
find.
that's-
Right.
I
But
know
I
exactly
mean,
where it
anywhere
is.
down in that area, I think is
Around
a
that,
little
it's
safer
lot- there's
part
a
of
lot-
Baton Rouge.
I have a home not too far from there, and there's a lot of condo development there, and a lot of stuff for sale on Sherwood Boulevard, Sherwood Forest Boulevard up in that area, so I'll see what I can find.
Okay. Any other discussion?
No, I just would like to make sure that we don't, because I know that we're well watched, and we want to make sure that there's no conflict of interest by a board member doing this on a gratis status.
She's just giving us information, that's fine.
Okay.
Right, yeah, we haven't entered into any agreement. She's just going to provide basic information. That will not be.
I'm going to provide you comparables.
She's not, right, comparables, right, and she's
what the
not getting
price is.
paid. It's just,
It'll probably take us another year to get enough money to do something.
And then we want to know what the management fee is going to be also.
Everything,
Condo,
right.
That's very important.
Yes.
Correct.
In Baton Rouge, it's pretty high.
And let me say this, the real estate office, facilities management also has that information. They can, you know, also give us some background on what's
We're gonna go on
available, what's in
multiple listings
compliance.
and see what you-
right.
Yeah, exactly.
Okay. Any other board discussion before I go to the public? Freddie, you have a comment? 1 second.
question.
1 second, let me get it on.
You said when it turns yellow, 30 seconds, right?
Correct. Well, I
I
don't
thought
know,
you
it's
were gonna
not
go right
turning
now.
yellow,
I
but,
wait till you get right there before I turn it
Thank
on.
you very much. 'Cause I couldn't see it.
yeah, I don't know if it's turning yellow, but I'll give you a nod.
Yeah, no, the
I'll
lights
wait
are
till you
on.
get
It's
there to
working.
turn it
Okay,
on.
go ahead.
My question would be, since in the history of the board we've not owned a building, what would be the feasibility of it now? Seeing that leasing has been, the way of the board since the beginning.
You could designate the ownership to the state of Louisiana with use for the board.
Correct. And which I think the state has available spaces that are also open for the board to go into that would be a lot more feasible than acquisition.
But what is the rent, sir?
Right now, around $500-600.
And that's every month?
Yes, ma'am.
It may be cheaper and more feasible to buy an office condo, but that's what we have to look into.
You have the maintenance and you have all the other things that come
The
along.
maintenance is usually included in the condo fee.
In the condo fee for
Right.
renting or ownership.
Well, if you own the condo, you pay a maintenance fee every month. That's usually going to run around $150 for an office condo in the Baton Rouge area, but I can get compliments. And I'm happy to furnish them.
It would just be in my best interest that the board would look at multiple options and do some comparative analysis to see which is feasible for, we don't know what the client or the board is going to be, membership and otherwise.
I tell you what, I will give you my card after this is over, and I'm very happy to hear any suggestions you may have.
Thank you very much.
All right.
You have remaining my time.
Yes, sir.
Thank you, Freddie. Anyone else? All right, I have a motion and a second. All in favor, say aye.
Aye.
Opposed? Ayes have it. Okay. Approval of financials. Is there anything to report on here?
Just approve the budget so far.
No, right.
I'll make the motion.
Have a
So we can
second?
discuss it. I'll second.
Any comments? You want to
Now
approve
we
the
can-
budget?
Did you have anything you want to add or no?
No, I'll just add that Mr. Lamar and I have had a very brief meeting, but I think beginning at the next board meeting, Mr. Lamar will be the one giving the financial reports, which I'm really happy about.
As the treasurer, he's going to take that over a little more
Okay.
detailed. Any other comments, questions? Okay. All in favor to pass the budget, say aye.
Aye.
Opposed? Ayes have it. Okay, number 2, attorney's report, investigative report.
All right, first of all, today we have a proposed stipulation as to findings of fact in violation of statute with regard to Gene vetoes.
All right, I need to turn over.
Yeah.
I'm going to turn over the gavel. I have recused myself on this issue.
Oh, that was perfect. Right
So
on
I'm
that.
turning it over to Mr. Sims.
You were gonna stay in the room?
Yeah.
She can stay in the room, she just can't vote.
Right.
or
I'm not voting or
comment.
anything. I'm just
Okay.
not commenting.
And Mr. Bordelot is the board member assigned to look into this. We offered a proposed stipulation to Ms. Vito's, who formerly owned New Orleans Auction Gallery in New Orleans. I'm going to pass out.
We need a motion, second receive report. That way we can have a discussion on the receiving report. Just want to ask you on that behalf. Is there?
Well,
Is this something that needs to be in executive session?
no, not yet.
Okay.
This is basically,
Just yes or no?
this is an investigative report, if you want to say just in general investigative reports, because I don't know that you want to say yay or nay to this report until you've had a chance to discuss it.
Thank you.
I would like to see a copy of it. I've never
That's what
seen
we're
a copy
doing,
of it.
okay. I'm passing out the one actually signed. This is not the one that was actually proposed to Ms. Vito's. I also have a copy of the changes on that, if anybody wants to see that also. Basically, Ms. Vito's, we had brought this up earlier, there was an issue that was discovered in the bankruptcy proceeding filed by New Orleans Auction Gallery, that the escrow account went into deficit, and NSF checks were issued as a result of that fact. Further, that consignors were not paid within the 60-day period, the 30 to 60-day period involved, until the bankruptcy was filed by New Orleans Auction Gallery, which resulted in the establishment of an escrow account under the control of the bankruptcy court, as well as the payment of all consignors, and that was monitored by the board as well as by the bankruptcy court, which ordered all of them to be paid out of the escrow account. Today, New Orleans Auction Gallery is still in bankruptcy. The bankruptcy court in New Orleans is still monitoring the escrow account and all financials, and is ensuring that all parties are being paid properly. The issue came to us on the question of the fact that because of the deficit in the escrow account, that consignors were not being paid timely. There's been no proceeding begun because of the fact that the matter is still in the jurisdiction of the bankruptcy court. However, it is coming out of bankruptcy probably this month, and the question is, how are we going to handle that? This is a stipulation that would cover that issue as far as Ms. Vito's is concerned.
I have a question. Is it Chapter 7 bankruptcy?
Yeah, no, it's a debtor in possession, Chapter 11.
Chapter 11?
It's for the company, not for her. She has not filed bankruptcy.
Well, I'm sure that most of you all know that with the Chapter 11 bankruptcy, debtors only receive a portion of the funds that's owed to them.
Well, no, this, as far as...
with regard to the referee in bankruptcy. No one is made whole with regard to monies that's owed to them.
Well, the consignors have been made whole.
You positive
Yes,
with that?
yes. I have a list of those paid, and we had a number of complaints filed with the office. All of those were taken care of. This is a debtor in possession. It's not a true Chapter 11. They have gotten financing, and they have operated in full, and all. We have had no complaints since that first set, as I understand it.
Why weren't they paid within the 30-day period? If the money was escrowed, I have a problem.
The escrow account was basically, checks were written out of the escrow account, were not supposed to be made
In
out
other
of
words,
escrow.
they were written out of the auctioneer's account for the escrow account for the auctioneer's own personal use.
For the company's use as far
For
as
the
I know.
company's use.
They
Well,
paid expenses out of there for
Is
the
it more
company.
than, was there more than one auctioneer operating this company, or is it just one?
This is not
Just
executive
one,
session.
there's just one owner. Now, Tessa was an auctioneer working for the company and was salaried. And we had one other, I believe, that was salaried at the
Robin
time.
Ruiz.
But Ms. Vitos was the primary owner.
Or was it personal debts of Ms. Vidros? Was it
Vitos.
your Vitos?
Um,
Was her personal debts that were paid out of it?
Not that I'm aware of, no.
Does anyone have a list of the personal debts that were paid? The
Yes, we do have a
personal debts?
list
Was it
of,
for the operation of the company or whatever? I mean,
I'm not sure it was for the operation of the company.
okay, because it sounds like there was probably some conversion of funds here somewhere along
Yes, there
the
were.
line.
Yes,
And that's
there
a
were.
serious offense.
Yes, it is.
Yeah.
So it would be up to the board as whether they want to entertain a stipulation or have a full hearing.
I would vote for a hearing on this, because I think any time that you don't make an accounting of funds to consignees, I think that's a very serious amount. It amounts to conversion of funds.
You put that in the motion.
I'd like to
Darlene?
put that in a motion, yes, sir.
Motion made that the board set a full hearing for New Orleans Galleries and Gene Vitos. Do I hear a second?
A second.
Motion made and seconded to have a full hearing for New Orleans Gallery and Gene, is her name Gene?
Jean.
Gene Vito,
Vitos, yes.
Vitos. Is there any discussion?
I got to discuss, isn't there an ongoing investigation on her?
Yes.
Well, I would suggest that we wait till this other investigation is completed, because there may be some more things that are coming up.
Who's doing the other investigation?
She is.
Oh, you're doing the investigation. Is there an investigation by the referee in bankruptcy? Have any of the creditors actually asked for an investigation or a
There-
non-discharge?
And you can just, there is no technical referee right now. There are some creditors who have issues with regard to other things than what we're looking at, to be honest with you.
If there's no, technically, if there's no referee that's been appointed, then this board, because it deals with auctions, is a referee.
Of these issues that are
Right.
within our jurisdiction,
I
that's
just think
correct.
that you need to look into it. I mean, you know.
Well, she is investigating it. I just think we're a little premature.
Well, we can go ahead and set the hearing, the date can be set later.
Oh, you can?
Yes, I mean, we can go
No,
ahead and,
that's correct. We
And
can-
I would like to hear, of course, your Madam Attorney, I would like to hear the results of your investigation too, but I think that the board has to look into it. Conversion of funds is a very serious matter.
But we don't have a complaint yet, do we? A formal complaint?
well, bankruptcy made that complaint.
Yeah. Right
Yeah,
now,
no.
it's in their hands. They kind of oversee.
But there's no referees.
What I'm saying, she's correct, but what I'm saying, we can go ahead and have her motion, vote for it, and then a hearing date can be set later.
Yeah, we can set it later.
You set a docket
Someone
date.
behind you
I'm
has
sure
a
we're going to have
comment.
to have a hearing, but we got more stuff that we're looking at.
Do we-
Yeah, the board, just so you know, the board had asked me to look into this, and because they're posting all their financials online in Pacer, we've been pulling them down, looking at, and that's the first thing you notice when you look at it.
All right,
But
the board
but
through.
Can we amend it to a later date, or to set a date at a later time?
You can set, she can do that, she can put,
Yeah, we can.
You can do that?
Yeah, sure.
Okay.
Oh, yeah.
And that's good with my second also.
All right, if y'all can reword that, we'll do that.
all right, we got public comment. Sherry, you
I
got
just have a
something?
question, why, the board has ample funds, why have they not hired a contract investigator to be able to spend a lot more time investigating this particular issue, as it is very complex, and that would free Ms. Gallup, you know, to be able to actually prosecute better.
Well, there is a contract investigator involved.
But he
Through
said
my
you were
office.
investigating.
Well, yeah, but it's under my control,
She's the one that
yeah.
reports to me.
Yeah, no, it's, I'm not doing this alone,
May I
believe
ask who
me.
the investigator is?
I would prefer not to say at this time.
I take it that the bankruptcy is pending in New Orleans? and-
Yes.
Okay. So therefore, it's accessible to the general public, so.
That's correct.
I didn't get that on.
Any other comments?
I'm sorry, I didn't hear.
Any other comments?
No, that was it. I just was wondering why there
Robert?
wasn't an investigator.
I'll be brief. You know, I think, as I alluded to back in January, there's a plethora of information available from Pacer. I have downloaded every document, and I'm glad to see that this board is finally taking the approach that problems here. And there's been some problems here. Been some problems here for almost a year. So, and I think Ms. Jacobs' point is very well taken, that this board is the referee of that. And I am really glad to see that finally, almost a year after the bankruptcy took place and the obvious problems were there, the board's looking into it. So that'll be it for me.
And let me just say this, we began looking at it when it first happened.
Alan, just a minute, you yield the balance of your time?
Sure.
Okay.
Okay.
Thank you.
Ms. Vitos does not presently have a license as an auctioneer. It was not renewed in January because of this. And this was the situation that left us with a decision as to what we're going to do with her license. So I'll go ahead and take care of that.
Was it not renewed at her choice or the board's?
It was at the board's choice.
The board's choice.
Well, then I would like a follow-up question then. If she has no license, by whose license was the March auction conducted?
That's New Orleans Auction Gallery, has a separate license that was approved by this board.
Is that still in operation now?
You owners, isn't it?
It's about to be, yes. No, it's been a separate entity since sometime last year.
Well, what? I'm sorry. I didn't mean to interrupt.
Well, I mean,
A business
the
license?
auction exchange is operating only because you have a qualified auctioneer there
That's
in
what I
order
was
to be
saying.
able to operate the business. Is that correct?
No.
The entity itself can't operate without a licensed auctioneer.
Well, it has licensed auctioneers on staff, yes.
Oh, they do have other licensed,
Yes.
licensed auctioneers
Yes.
who are not affected by this lady's auction
That's correct.
certificate.
They were just strictly employees, no.
But they are licensed auctioneers?
Yes,
Okay,
yes.
good, okay.
Was it issued a firm license? Is that the deal?
That's correct.
Okay, that's.
It has a separate firm license.
Yeah.
I don't remember what date, but
That's
that's,
what I thought.
as a result of all this, we requested that they obtain their separate license.
Right
because-
after bankruptcy
Right
filed.
after the bankruptcy was filed.
And you say that it's now under operation with new owners?
That's possible that after I believe there is something scheduled this month to change the ownership. It's been pending now for about 6 months. There have been a number of, it was either going to go to public bid or it was going to go through a procedure within the court, and I think they're about to resolve that, is what I understand from the court proceeding.
Robert.
It may or may not go. As you're aware, MS Rao is one bidder, Susan Crone is another bidder. Those are the only two known active bidders. Mr. Schaffenberg pulled out.
Right.
But there has been a competing plan put forward by New Orleans Auction Gallery that extends out for as long as 7 years. They do have the prerogative to accept that plan if they deem it to be in the interest of the best creditors. So it's not a foregone conclusion that the firm is going to be, that means I'm up?
No, I forgot to press it,
Oh.
so you got a little extra window there.
So, it's not a foregone conclusion that this thing is going to emerge under different ownership on March 29th, which is the ballot date.
No, and that's true. That is true, but it's, depending on what happens, then, well, of course, the board is going to continue to monitor this and make decisions with regard to how to handle it, depending on what happens in the court proceeding. Right now, because it's being monitored by the court directly, we have not been concerned about the status.
All right, well,
Until it comes out of court, Robert, there's really nothing we can do.
What I'm going to try to do, I'm going to try to get a copy of the schedules in the bankruptcy proceeding, and then I'll send it to Sandy, and Sandy can distribute it.
We have it. They've been
You have
serving
that?
us, yes, and I have a
Because,
copy.
I would be interested to know who the creditors are and make sure that everybody's been made whole.
Now, the creditors I don't know about. The consigners have.
Well, I'm talking about people that have put stuff on consignment to
Yes,
the auction house.
as I understand it, and I've looked at the records, the consigners themselves have been made whole except for 2, and that is not a dispute as to whether or not it was sold. It was purchasers who are concerned that they bought something they didn't understand what they were buying. So those are 2 pending disputes that are in court proceedings separately.
I have one last question.
You done, right?
well, and to that point, one of those, who is a member of the Unsecured Creditors Committee, there was $75,000 scheduled in legal fees alone on a given date pertaining to his claim. The other one, I can't remember his name, but he too, so it's arguable. I mean, I realize they're on the other side. You know, it's arguable to say that, yeah, consigners have all been paid, but you have bidders that clearly indicate that they have valid claims.
If you're talking about legal fees on the buyer, then
I'm
there's-
not concerned about that.
I'm not,
Everybody's gonna
nobody's
get paid a
concerned
lot of
about that
times.
because that's non-collectible.
That's
No, I'm
not
talking about
fair.
legal
Right.
fees
They're out.
that New Orleans Auction Gallery owed have a flash point in time that was owed in relation to that matter.
That to me is not as important as making a consignor whole.
Well, the consigners all got paid when
Because-
Mr. Schaffenberg stepped up with
Well,
460, whatever it was,
But
400,000.
you just said he pulled out of the buy process.
That is
right?
correct.
Yeah.
He went in November. He is a CPA. He made some recommendations to them with regard to their accounting system. New Orleans Auction Galleries basically said as a result of that, they would hire a forensic accountant to try to sort through some things. And I'm not going to mention the name, but I assume that surely this most recent filing that involved $2 million, I'm sure that's bound to be, I know that the New Orleans Auction Gallery said they're going to look into it, so I assume that it's going to be looked into.
I have a question, please.
That's it.
Is that all, Rob?
No, yeah, I'm done.
Yeah, Sherry.
Sherry?
Okay, so as I understand this, Gene Vitos' license was not renewed.
That's
By
correct.
choice of the board as of the first of the year.
That's correct.
But New Orleans Auction Gallery was issued a firm license.
Right.
To someone. Who was the owner of record that his firm license was listed?
It's a corporation.
The corporation itself, it does not, because it's in bankruptcy, it's not, it's theoretically, Ms. Vitos has stock in it as well as others. And
Whose name is on the paperwork, man?
Whose name is on the corporation? That's what I want to know.
Whose name's on the corporation?
Is this an LLC with 100% ownership of one person?
No.
Or is it an LLC with ownership of 5 or 6 people?
Actually,
Are they auctioneers?
that's part of what was in dispute in this matter.
Okay.
But that's what I'm saying, is because it was a separate entity, and because all of these matters being resolved by the bankruptcy court, because there were individuals who came in and said, I have an ownership interest, I gave money to them, I should have stock, I should have ownership. So we left it in place because it was being monitored by bankruptcy and by the court, the judge directly. And it had other licensed auctioneers on staff. For the most part, the only reason, we would have had, if we shut down a company that was in bankruptcy trying to earn money to pay creditors, I don't think that the bankruptcy court would have allowed us to do that.
You can't shut them down, but the question remains is whether or not any of the stock of this licensed corporation, any of the holders of the stock, are in fact licensed auctioneers, and whether or not their license had been revoked, or maybe it's the only licensed auctioneer that owns corporate stock, Ms. Vitos. I would be interested in knowing that.
Yeah, I think she's the only one of the licensed auctioneers who actually has
you have a licensed corporation with no licensed auctioneer, and I have a problem with that.
What about staff auctioneers that are licensed?
Wait.
They're not owners of the corporation, and you license the corporation.
Wait, our statute does not require a licensed auctioneer to be an owner of an auction firm. It's a separate license. And we have a number of auction firms that do not have licensed auctioneers as owners.
I think that's a problem.
Well, that's what the statute, that's the statute.
What happened is we gave the license to Gene Vitos' corporation, so basically we just gave Gene a business license.
No, because Gene doesn't have any control over the organization right now.
Well, because it's in bankruptcy.
Because of bankruptcy, and that's what I wanted to clarify before it comes out of bankruptcy. I don't know when that's going to happen.
Question to I know both of y'all are attorneys, so whichever
I still
one,
am.
whichever one wants to answer.
Right.
Under the Federal Bankruptcy Act, I know this is a Chapter 11 debtor in possession, correct?
That's correct.
Okay. I don't think this board could legally deny a business license. I think the court could order us under court order to issue a license through the judgment of the judge. And then it would be held, he would be the responsible one, even though he's not a licensed auctioneer, but he's an officer of the court.
The court can't,
They can,
he doesn't have that responsibility.
he doesn't have the responsibility, but as long as it's a debtor in possession, Chapter 11, I don't think we can take the business license.
You can't take the business license, but when they come out of bankruptcy, and if they are actually in Chapter 11, they are apparently trying to reorganize.
That's correct.
That's
Then we
definitely
can take
something-
it.
Then you surely ought to look into it.
That's what I'm saying.
I know,
After it clears
you know,
the court, we can do
As
it.
a realtor, and I have a corporation, My corporation's license is based upon the fact that I'm a licensed broker.
Okay.
I think that's important.
Is there any other discussion, any other questions?
Yes.
Freddie?
Two questions, and let me just say this, Greg, before you start, because I watched
Hey, you're on the
Robert stand
clock.
up here.
Already started, so
Okay,
you
well,
better get it.
I
All
watched
right,
him stand up here.
let's go, Freddie.
I wanna
Instead of
make a
arguing
statement.
about the clock, go ahead.
Because he stood up here and he never said the 5 things, and then y'all talked, and then his time ran out. The point
Who?
I'm making is, that's what, he has to have 3 minutes of time.
Who's that, who's with you?
Robert.
Robert, I gave him an extra minute and a half.
Robert
'cause I forgot
yielded
to
his
start it.
time back, Freddie.
Okay, let me just say what I'm seeing happen. So, you all are having discussions, and then the person standing up here makes one statement, and that's all that's going on. But my question would have been, that Ms. Norris Auction Gallery was issued a license under a different, assumably a different auctioneer that's licensed with the state of Louisiana in good standing, and who has to take what I could call full responsibilities of the auction matters. Someone asked who was that auctioneer. Well, you have to have a licensed auctioneer to conduct an auction in the state of Louisiana. If not, then the auctioneer is considered loaning his license, if he's not in control of assets and what goes to the license. Correct me if I'm wrong.
The court's in charge of assets. Then there ain't nothing
But
you can
that's
do about
correct,
that.
But the courts also stipulate in hindsight that the auctioneer that's standing up, that's taking the full responsibility of the auction, has to also be accountable to, because their license is on the line. Correct me if I'm wrong. And that's what we are now.
Well, I don't know, Freddie. I mean,
Jacobs-
you was on the board when they voted to give the license, so that happened last year, right after I got on the board, and you sat there and voted for
I
it.
wasn't aware that New Orleans, Ms. Beals did not renew a license, and I wasn't aware that someone else had stepped up to the plate to put that license in place. And that's where someone else has to be there with their license in place.
Well, I know there's 2 other licensed auctioneers in this state that's working there.
Okay, and what is their responsibility?
I have no idea, Freddie.
Well,
They're
that's what I'm
working for the
asking. That's why I
court. They're
just
working for the court.
Oh, they work for the court? Is that the case? The
I mean, they're in debtor in possession. They're working under the control of the court.
Who's
Well, if you're asking me, I don't think that's correct, because in the 42 years that I've been practicing law, I mean, the federal bankruptcy referee, and there's none appointed yet, or a federal judge that may eventually oversee this in bankruptcy, is not going to determine the licensure of an auction company, and whether or not the company has to maintain its license in order to get out of Chapter 11. That's not something that they would do. That's something that's delegated to the board.
That's correct, and that's what I was saying. And that's why I'm wondering why we discussing moving to the side when the issue's at hand.
And I would like to know,
the
what
board
the
needs to
cause of the
address it because it's
bankruptcy
been
is,
over
how
a
many
year.
people, how the
And
funds were
nothing's been done.
diverted. I mean, I would like to know that. That's
And I
serious.
certainly can provide that to you. I may even have it
Okay,
with me today.
all right.
Is that all, Freddie?
Yes, it's been over a year and the board hasn't done anything about it. That's why I wonder why it's taking so long for something to be done.
Is there any other discussion? Any other public comment? Hearing none, the board will proceed to vote. I'm going to ask Ms. Edmondson to do a roll call vote on this with the exception of Ms. Steinkamp, who is chairman, who has recused herself.
Mr. Brister, so the vote officially,
Yeah, read it
yes.
again.
It is a motion to set hearing at a future date
Set a hearing at a future
On
date.
Gene vetoes.
on June
On
5th.
Gene vetoes. At a future date to be determined by the board representative, which is Greg Bordelon, and the attorneys involved.
Once all the
I would like to
information
just
was gathered.
correct the motion and make it a little bit more succinct. The motion to set a hearing on Ms. Vido's as to whether or not she should maintain her auctioneer's license at a later date.
Her individual license.
Right, her individual license.
I'll adjust my second to that.
Okay, motion's been adjusted. There'll
Okay.
be a roll call vote with the exception of Tessa Steinkamp, the chairman, who recused herself.
Mr. Bordelon,
Yes.
Mr. Brister,
Yes.
Ms. Jacobs,
Yes.
Mr. Little,
Yes.
Mr. McMillan,
Yes.
Mr. Sims.
Yes. Motion is passed. I turn the gavel back over to the chairman.
Thank you, Mr. Vice Chairman. I appreciate it.
If we could also go to the, as you know, the legislature is in session. We have been monitoring the bills as best we can. The legislature has been sort of preoccupied beginning at least, with a various number of issues. There are only 2 bills that specifically name the Auctioneers Board and the Auctioneer statute in them. The first is one that is referred to as a housekeeping bill, and all that has occurred with regard to the board is the fact that the name of the Sanitary Commission in the livestock auction sections is changed to the correct name of it, and I meant to bring that with me. I don't remember right offhand, but it's changed its formal name, and that's the only effect. So it has no direct effect on the board itself. It's simply changing a reference in our statutes. The second bill is SB 590 by Senator Ilaria, which is also a housekeeping bill. In this bill, Section 3119 of the statute is being repealed completely on the grounds. This is the statute that basically says that there is created an auctioneer's licensing fund into which all fees of the board, paid to the board, are to be deposited in. At first I thought they were trying to simply eliminate our ability to deposit funds into our own account. I am told, however, that the purpose of this is that that statute, which was passed in 1984 and has never been amended or repealed since, is that the original statute referred to an accounting fund within the general treasury. We have never put our funds in, paid our fees into the general treasury. They've always been kept separately. And that because this would appear to create a problem for us that we've been depositing it in since 1984 into the wrong account, they're just going to repeal it outright. And this would have no effect at all on our operation. And we did get something in writing from Mr. Ducey at Division of Administration to that effect. That was the only purpose for deleting this particular statute.
So, under comment, it was said early on they were looking at raiding our account, taking it and moving it to the general fund.
He says that is
not true.
That is
But
not
that's
true.
what they said early on.
They
And we're positive
originally,
that's
when I
not true.
looked at it, when you're deleting the section of our statute that says this is where we put our money, I took the, I got the distinct impression they want us to put our money into the general treasury, and I'm told that is just the opposite. That what they're actually intending to do is to remove our obligation to pay into the general treasury. It's very unclear, but I got it in writing from the Division of Administration to that effect.
And that's what we have been operating under, the assumption that that could happen. They could until recently.
Yeah, obviously, but no other boards, and obviously on the big scheme of boards in this state, we're not the biggest by any means as far as money is concerned. So that there was no other attempt, and the rest of the statute, I do have a copy of that statute with me today, is basically housekeeping. It's just clearing up various statutes to make sure that everything is being done correctly.
1 second. Can he comment on this without a motion?
Yeah.
I mean, he doesn't.
Public comment on anything on the agenda. So, unless the board seeks to do otherwise, we're not going to appear in any committee hearings on this or to talk to any legislators about it.
Well, do you think it's... Freddie, you have a comment? You want to step up? Or you want to stand up? We can hear you. You want to hit it,
I
please?
don't need to do that. I just got one question on this now. Are they saying technically that they want to see, they're not trying to move the money, but they want to see where the money is within the LALB?
No. It has nothing to do with that. They're eliminating a statute that says we're supposed to be depositing our funds into the general treasury.
But they're not interested in watching the day-to-day operation, because housekeeping normally typically goes with day-to-day operations.
No.
So that's not the language.
No.
Intent.
No.
You have the right time.
Any other comments? Okay. Attorney's report continues.
That's really all I have. There's some other things on here that are later on in the agenda.
Okay. So do I have a motion to approve the attorney's report?
A second.
I have a first and a second. You have a...
Yes, I have a question. On not 3, 4, and all the rest under the attorney's report?
No.
1 and 2?
Just 1 and 2.
Just 1 and 2.
Veto stipulation, legislative report. Okay, any other comments? All in favor to approve the attorney's report, say aye. Aye. Opposed? Ayes have it. Number 3, the lease report. As you all know, the last meeting, we had a little committee for Mr. Lamar and I to discuss the lease. I have had Sandy put on here, and I'm trying to find mine, your fact sheet. This is the fact sheet. I have, and I'm just going to give a report on what Mr. Lamar and I have talked about this several times. Here's your fact sheet. Just to give you a little update, Darlene. The building we were in, we were asked to move. We had to move because of, what is it, lead? What was it?
The building was being sold.
It was being sold.
And they asked us to all
then the
move
first
out.
one we found, we couldn't move in because of the lead, so then we moved here. They paid all of our expenses and everything for us to move. It didn't cost us a thing. So here's what we were paying, what we are paying, and we have been. And there's been some complaints from, I believe, Robert and Freddie about, and some, maybe, I don't know, everybody who's concerned that the board was paying more than the interior design was for the conference room. I spoke to the chairman of the interior design board on the phone and relayed this to her. She understands that. I asked her what kind of plan could we come up with. She was going to meet with her board and get back with me. Her mother's been in the hospital. She's been with her recently and has not had the chance to email me their proposal. I do know what we have spoken about so far has been that they won't use our conference room, that they'll just go have their meetings someplace else, and they just won't use it. And then they would want us to pay them for their portion of the lobby. So I'm not sure what they're going to propose to us. I am in negotiations with her, asking her if we can mutually come up with a deal that would please everyone. Not that that's possible, but I will continue to work on that and should have another update for you by the May meeting as to where we stand on that. Anybody have a question for me or Mr. Lamar about this?
I have a question. Louisiana Real Estate Board, they have their meeting. They only meet, I think, 3 or 4 times a year. Is there any way we could lease space from them when they're not meeting on a very nominal basis?
Well, here's the thing,
We
too.
only meet 4 times a year.
That's where we were on Summit Court until they moved down.
Right.
So where are they meeting now? Because that's a pretty active board.
Yeah, they meet at their building.
They built their own building.
Yeah.
With
Well, I mean, is there any way we could,
Well, see, we have to have our
accommodations?
we have to have our applicants come in and test. I mean, it's not just, for that as well, and it's also a space for, if I have a meeting, other than the meeting, I have to meet with an attorney or something comes up, I need an office to go to. Sandy needs an office to kind of keep everything in our files and all that. So we do need an office, and this was perfect. I mean, the conference room, there was issues with the size if we have like a big hearing or anything, but it's not an issue because we can get this, or we have other spaces available for free. The big issue was we were paying more than the other board for the conference room, but we were renting them the chairs, so they're fine with not using our, the conference room. They don't have a problem with it. They'd love to go somewhere else. Actually, they used to go to lunch for their meetings with, at a restaurant. So, anyway, she is going to work with me on this. She's going to work with me on this, but her mother's very ill and she's been at the hospital and hopes to get back with me soon.
Tessa,
Yes, sir.
I would like to know who
Somebody hit that.
named this lease.
Will you hit that so we're just to keep it?
Other reset.
Correction.
How is the lease, who's responsible for this building?
For this building, I have no idea.
No, the office over.
Oh, what do you mean? Who's responsible?
Well, who
Each
leased the
agency
building?
has
Each
their,
agency.
has
Okay.
their own lease.
We each have our own lease.
Okay, all right. What does the interior design pay for the building? Rent per month?
The interior design board pays $300 a month rent. No.
Okay,
For the 234 square feet, that
Right.
is their office.
okay. The auctioneer license board pays how much rent?
$660.
Okay. Why would we pay more rent than they do? It never was before. It was always 50-50 down the middle.
Well, at Summa Court, we paid $660 and they paid $300.
Well, that's got nothing to do with Summa Court.
Actually does, that's the problem.
That's the whole problem.
This email, yeah,
See, it
My
says,
problem is, and I've been kind of involved in this from the get-go, and they are getting the building, the same building that we got, that the auctioneers got, for less money than what we pay.
right, and they
Okay.
have done so in the past. This isn't the first time.
When was this?
Summa Court,
Right here.
Summa Court, they was not together, right? Not to start with, they were not together.
They're not
No.
together now, they're still separate entities.
Excuse me,
Well, that's-
Sherry. Guys, can we do one at a time, please?
you want me to?
Yes,
address
I
it?
do. I'd rather you address it,
Let me go
Anna.
back and just go back. They're separate entities, they're running separate places right now. When they were at Summa Court, what happened is that we still had a lease in place that was properly filed. At the time that the owner came in and says, I'm selling, y'all have to get out. Now, the way it worked was if, by law, if we left at that point, any difference in rental that we had to pay or interior design had to be paid had to be picked up by the building. So therefore, what they decided at real estate leasing was that we were going to try to find a place that would keep us both at the same amount, so we would not have this issue, and we wouldn't have to rely on the new owner of this building making up the difference and paying us money. For whatever reason, that's what they decided. So we ended up working out a deal where we both went into the same building at the same percentages of liability that we had before. So they split it up by square footage arbitrarily in my mind, which I don't think they need to do, but that's what they did. That's why you have the two amounts there at this point.
Well, that's fine and dandy, but I think that an auctioneer should have been involved. This board should have been involved in renting a building. Don't think they were, and I think it's unfair to the auctioneers to pay more money for the building that you're sharing with interior design. I don't think that's right. It wasn't right before. You was running for both boards.
But back originally, yes, it was
Okay.
when we were
And-
together, it was
and
50-50 split.
50-50.
Yeah.
Yeah. So I would think that's the way it should be now, or if the auctioneer is having to pay more for the building, that's not right.
And I am talking to her about that, and
You're right.
I'm waiting on her proposal, but I was trying, didn't really think it was, thought her mother,
Right,
Freddie,
I understand
Sherry's in
that,
front of you, if you would
But my
just,
thought, my deal is
Right.
that it should be the same.
thank you. Sherry, you have a comment,
For
you hit
those of
it.
you
1 second,
who
Sherry.
were not
Go.
around when the two boards split apart. The two boards initially were housed in the same building, shared one employee, each board paid half of everything. In 1999, those two boards split apart. I was hired to come with the LALB. The person who had previously worked for both boards went with the interior design board. We split everything down the middle and we became two entirely different entities with entirely different tax ID numbers, entirely different bank accounts, everything. The LALB was now a singular entity, the IDB was a singular entity. It just was coincidence that both boards were in the Summa Court building at the same time, paying different amounts. But they were paying different amounts because they were separate entities, renting separately and renting separate amounts of space, okay? That's why that was in Summa Court. When they moved to wherever it is in Newcastle, they're still separate entities paying separate amounts for separate square footage. The only difference is how the communal area of the conference room was split apart.
Right.
And that was the inequity, is the conference room was not, the rent from the conference room was not split evenly. And it wound up that the interior design board wound up paying less for use of the conference room than the auctioneer's board. Do you understand all that, Larry?
Yeah, and she's absolutely right.
Right.
She's
Yes, we
absolutely
do,
right. That's
I
exactly what
understand,
happened.
but that's what happened. So wait 1 second, I have Freddie in front of you, and then we'll come back to you, Larry. He had his hand up. All right, you want to hit it?
Got it,
Yes, you have a comment, Freddie?
Well, I have a question as well concerning that particular space.
Clayton,
With both
hit it,
entities,
Clayton.
it's not on.
It's on.
No, it didn't. It
start.
stopped. Okay. I know why it stopped.
With both entities being separate, then why did they not look for separate buildings to be housed in when they were not up under any obligations? That's what Sherry just mentioned, that they so happen to be at the same building, renting under separate contract leases and everything else. Why would we try to combine something that was separate, the main line going down the road anyway? And that was just creating a problem where we're sharing space with a building and we're utilizing it when at the other building, technically, quote unquote, it was never that case. Although the conference room was there, it was not a part of the process in the first place. We were getting what we paid for. So the question that I would have is, what we can do is probably just part ways and let the LALB maintain its own course and let IDB maintain their own course. And I think whatever disagreements and problems we have will be resolved with that issue. I think we can sustain ourselves, and I'm quite sure that the IDB can sustain themselves. So, you know, that's what the problem is. It's not fair that we pay so much of it and we're sharing the same building. And that's what I had concern with, and that's what Larry said. I felt that the auctioneers should have been involved in that and going in there to see that the building was adequate and feasible for what we needed and not been a conflict of interest. From the offset, I yield one time.
Robert, you have a comment? In 1 second, Robert, let me get this. Okay, you ready? Ready, Robert?
There was nothing arbitrary about the square footage allocation, and each board member's gotten the floor plan. Rooms 2 and 5 went, well, I may not have the exact rooms right, but anyway, it's broken out. I've repeatedly provided the floor plan that calls for this. Just as has been reiterated here, you know, it was we got stopped paying the full cost of the conference room. When I say we, the LALB. I guess it's ironic that when we insisted on equality in that, because I made the statement that we should, the LALB should have to pay its hand of that front lobby. To do otherwise is not fair to the interior design board. But I do find it ironic that now that we've insisted upon that equality, apparently the response is, we're out of here. So if that's the consequence of the auctioneers insisting upon equality, then I think we've done the right thing. And it would be appropriate for them to vacate and not use that conference room. I will ask the question, they owe us $800 for their use to this point of the conference room. Nobody disputes they've been in there. In fact, when I was able to go in and video when there was no problem with me plugging in my video cameras, which I still take exception to today, but I'll deal with that at another time. But I think if that's the end result, that they said we're out of here, then I don't think any auctioneer should hold their head down that we insisted upon that inequality. I wouldn't change a thing, and if they're gone, they're gone. The added cost to us, we're already paying the conference room. We're already paying for it. The added cost of that front lobby up there is going to be about $25 to $30 a month. I don't think any auctioneer is going to lose any sleep over now having to pay another $25 or $30 a month. And wherever they go, I assume there'll be an agenda posted that'll let us know where they're going, because I'll certainly be there to film those meetings as well.
Thank you, Robert. Okay. So, any other questions about the lease report?
I just have, I'm sorry. I have a question. Do we have now a recorded lease with them?
Yes.
We do, and what is the duration of the lease?
Yes, it's a standard state lease.
Where are we with respect to that particular lease?
We just moved in October.
But we can break the lease with 30 days.
Robert, one at a time.
But we
Just
can't
wait.
cancel it?
We can cancel it with 30 days notice,
Yeah.
as any state leases can be.
And it's not, there's no penalty?
Nope.
Okay.
No, it's a standard state lease. if
Good,
you've
okay.
seen those.
Paul, did you have a question?
Well, I was just going to comment, we are working in a very positive direction. We're going to be looking at the opportunity with capital outlay funds to
Yes.
probably find another
Correct.
completely owned building by us.
Right.
For time being, I guess I'm just a proponent of something is better than nothing or nothing.
Right.
I'm glad I'd like to see it at 50%. Hopefully in your negotiations
Right.
you can get it to that. But if you bring back something that's 80-20 or 70-30 or 60-40, whatever, then this board will make that decision at that
Yes.
point in time. But I think we are being very proactive in looking at opportunity to own our own building in the future. So
I
that being
see you.
said, get us that data, then let us digest it, and then we'll make a vote on it. Thank you.
I will, and I'm still negotiating with her. I just, because of her mother's, I think, critically ill, so I wanted to give her a little time, and I don't think, we're talking about a few $100s. The world's not going to end over this. So that's what's more important. And we are in active negotiations. Can he comment again?
He still had about a minute. 20
You got about a minute.
You have a minute left, Robert. Would you like to?
I mean, I know you said both sides. Apparently, at one point, she said, we'll just leave.
No, no. I said she discussed her options. She says she understands what's going on, and she is going to go to her board. They're going to make some recommendations. Obviously, one of her options they won't use the room, or they can pay more. No. She didn't say this is it. We're negotiating.
Okay.
Okay, we're still in negotiations.
I will withdraw my commentary that made the inference that they had made an indication.
No, they did not. You misunderstood me. I said that was one of her options.
That's why I wanted to clarify.
Right. No. She is still open. She's going to put it in writing to me as soon as she takes care of this. But, you know, we can deal with...
Well, and
it's not over.
We do have an obligation to pay for our half of that front lobby. It's wasted space, but it's got to be paid. Right now, they're paying all of it, so...
Okay. Well, they're not worried about it, so... All right. Next, number 4, we have public records request policy. All right, due to the number of public records requests and how we receive them, just to keep up with them, we've kind of come up with a form that we can do. Did everybody get a copy of this? In order to maintain...
Should be the last thing in your packet.
Should be the last thing in your packet. In order to maintain compliance with the Louisiana Public Records Law. Everybody has a copy? Mm-hmm. Okay. So this would, what we're proposing here would be a motion to put this into our...
Can we get a copy of it?
One second. Let me get a motion, then we'll go to discussion, okay?
I mean, we don't know what you're reading or what you're looking at.
Okay, I'm going to give it to you. One second. Do we have any more copies?
It'll take me a minute.
Okay.
I gotta find where I put them.
Take mine, I'll look at it.
I was trying to find mine too. I don't know what I did with it.
I have one more copy.
They can have it.
If someone wants it.
All right. So do I have a motion to put the new public records request policy into act?
I so move.
And do I have a second?
I'll second.
I have a first and a second. Does anybody, we're going to start with board questions, then I'll go to y'all. Anybody, you have a question, Greg?
There's no, do they also have to pay for the postage and stuff too? I see it's 25 cents per copy.
No, DOA only allows 25 cents per sheet.
Per sheet, not no mail.
No postage.
Now, how do you mail it back?
Certified.
On a request, certified?
Typically.
Okay.
Anybody else have a question? You guys have a question? Any comments?
I have a question.
Come on up. Hang on one second.
Okay, I thought you were talking to me.
No, I am. 1 second. Okay, ready? Okay, we're ready, Freddie.
Oh, I couldn't hear.
No.
I've got one question concerning what you're suggesting here. You're saying that, you know, under this particular statute.
Right.
This is typically what is done at most state agencies.
Correct.
But when it comes down to most of the time public records requests, is it customary that the request be mailed?
Yes. For the most part, yes.
Okay.
It does require you have to do it in writing, and you have to make the request in writing.
Because I thought I read in the statute that it was one of 3 forms in which a public record request could be submitted.
Well,
now,
that's...
I may be wrong, but this is, you're saying this is the only objective. I think it's one of 3 ways that you can do so. And it's not just in writing.
No, that's what we're saying.
Yeah. This would be
This would be the
clarifying.
only way we're clarifying that.
So y'all
We're changing it.
revising-
Yes, this is a revision, correct.
Okay. So
Of
you're
of our
revising.
practice in the
Right.
past, yes.
Okay, so y'all limited to, so what does that do with people who don't have access to technology, things like that? How do they comply with this?
They can handwrite a request and mail it in.
Yeah, we want it in writing. You know, we've had some issues in the past, so we would like this in writing.
And this is boards and the board and public, correct?
The board, I'm sorry.
The board members and the public are the same guidelines?
A public records request is the same for everybody.
Yes.
Well, I'm just making sure.
Yeah, well, yeah.
Yeah.
Okay, so the board second. That's what I want to make sure. So you're going to revise it so it's only in writing only?
Correct.
And that's in compliance, just for the records. That's in
I don't
compliance.
understand the question. Is that in
Yeah.
compliance?
With what?
With the state law, regulations.
This is a policy to implement state law, that's correct.
Is it one way, one form only? Is that the only way? That's what I'm asking.
Yes, that's what the policy is saying, yes.
Yeah.
I think that's what I
Well,
guess I
you're
understand your
making a
question.
revision is what I'm thinking you're making here. That this
We
is
would,
what
yes,
the
we're
board
making a
wants.
revision, Freddie, you must put all public requests in writing.
Through the
What
mail.
we're
Through the
doing-
mail.
We're following the state law.
Right,
It's a public records request.
Request,
It should be
right.
done in writing, and it's charged
right,
for that.
right. And I mean, it's been, done to
You wanna make
emails,
sure
going
that
in
everything you
spam.
get is
Right,
authenticated.
right,
And the
in
only way you
writing.
can do that is to be able to get those documents in this way.
That's what I just want to make
Right,
sure.
and you can just mail
Document it
it.
on
You don't need technology,
Why it's
just
done?
mail
Okay,
it. No
that's what I'm saying.
technology
You
needed.
go
No,
to
no, no. No, in fact, it's easier, you don't need technology.
No problem.
All right, Robert, you have hang on, let me fix the thing.
Okay.
Robert, you have a comment on this?
Well, yeah, I would ask, would it ever fail to get it in writing? Ever?
Yes. We, on one occasion, there was a conversation between you and a third party in an email where it was not directed to the board. And that's one thing we wanted to clarify, that the requests have to be directly to the board and not as a casual aside. So we don't have these issues of who asked it, who was supposed to get it, et cetera. So,
Just going to keep it real
yeah,
clear and
we're
neat
trying
in
to
writing.
clarify it and make sure it's simple and to the point.
No problem, and you feel certain that the restrictive covenant of the certified part is not in conflict with accommodating public records?
I believe you and I and Freddie were in court one day when the judge said it should be by certified mail sent directly to the board.
The response or the request?
The request.
One at a time. It's Robert's 3 minutes. Sherry, I'll give you
I don't recall
yours.
the judge saying that. but-
Yeah, he did.
Well, I recall a few other things that I don't think you recall, so I guess each of us has some.
Okay, Robert, let's just
some
keep
other-
it,
I didn't say anything specific this time, Ken. I just said, she said it did, I said it didn't, so that's a fair
Okay.
assessment. There are some other things that I say he did that she says he didn't, so. Well, all I know, and you were there, Ms. Steinkamp, when the legislative hearing was discussed about public records, and the sentiment I got from the legislators were that you were to be as accommodative as possible. So
and putting something in mail, I don't think that is very
That's very
accommodating.
accommodating.
It
I'm asking
is.
about the certified part.
It's very accommodating. You just go to the post office.
I'm asking about the certified part.
Right, we
I'm
would
asking
like
if
it
someone has
certified,
checked
right.
To receive, that's why Ms. Dow says she heard the judge say that. I'm asking if the certified
Now, you asked
part-
and answered.
Pardon me?
You asked and it was answered. Asked and answered.
And I'm gonna ask one last time, are you certain that is a requirement in keeping with facilitating public records requests? And if you tell me yes, I accept it. Ms. Dow, you want to say yes again?
What do you mean?
Well, she pointed to you saying it was answered, so I'm assuming.
I think
put
she
it-
answered it also. What we're doing is to make sure that we get it, that you have proof that it's received, we know what date it was received. This is to facilitate the meaning of that particular request, so that it can be, basically there'll be no issues involved.
Really?
Some of the things we've had where we've been getting, public records requests at 11 o'clock on a Saturday night sent by email has generally raised some issues that were not apparent before. And that is why we have discussed this with the Attorney General's office, as far as making sure that this could be something we could do as a board to clarify those issues.
I have a question. Do y'all have a stamp which says that this is a certified copy of such and such a record?
I don't know if
I'm
they have a
gonna give
stamp, that's what we put
I'm gonna
on if
give
they
you more-
request it,
another-
yes.
Right, okay.
I'm going to give you another 30 seconds. You want to hit it because they were talking. Okay, so anyway, before you hit it, let me just say this. Robert, this is just a way. Certified mail is easy. You go to a post office, it takes 5 minutes. You just do it. This way we know it was, 10 minutes. That way you know it was done. We won't have, oh, well, I sent you a public request in the mail. Well, I didn't get it, so we're not going to have any issues. It was mailed, received, we will respond. It's
Well,
just simple.
I have no problem.
Okay,
As
good.
this board, I'm sure is aware, I don't get anything unless I jump through the hoop. So I'm talking about even as simple as the financial statement that you all got today. Yes, I made a request at 11 o'clock as a reminder that I want that. I have made the blanket statement that I want them for every meeting. Are you telling me it's going to be okay that I don't have to do a certified letter each meeting?
No, we want a certified letter.
Yeah, you can't make a blanket request. You have to
Right.
request it each time
Each
you want the
one.
records, is my understanding.
Well, I'm going to challenge that then. I mean,
Okay. That's
if
fine.
I can say I want it for the next year, and it's been made clear, and there's been no change in personnel, to suggest that I have to send it each time, and I have to send it certified, it's clear where the board is going with that. All right? It is very clear, and that is something that, extremely easy to produce.
Okay.
And the same thing goes with Ms. Dow's invoices. And so,
Time's up.
that's once a quarter, but,
Thank you, Robert.
I think,
I see you Friday.
I think this is challengeable, AG's office or not, it's certainly challengeable.
Thank you, Robert. Okay.
It won't be the first time that they can
Robert,
lose inside.
thank you.
I have a
One second,
suggestion.
Freddie, I'm
Why
gonna-
don't we just have some extra copies at every meeting? And,
Thank you, thank you.
I mean, I don't see a reason if the
Of
public,
what?
of anything that we have, I mean.
Oh, yeah, this stuff.
Yeah, make
Oh,
5 or
yeah.
6 extra copies.
That's not a
and then
problem.
They can,
We can put it on the chair.
Well, then scratch that request.
Right.
I mean, Sure, he said it's okay.
Freddie, you have a question?
I only have one question, and I'm gonna stay right here so you don't have to clock. My question would be, if you send something certified and it's not received and no one's at the office, and how do you all address that issue from the time that it's mailed until the time they request?
We get our certified mail, Freddie, don't worry.
Ma'am, I didn't ask it. I just asked a simple question.
I know you did, but
How would you address it?
we get our certified mail, Freddie.
So,
They leave you a receipt, we get our certified mail.
Does
If
the clock start when they leave that little note?
When we receive the
What?
request.
You want to see the request. And I don't think in the past there's been an issue with
there's,
that.
it's never been an issue.
I
Well, don't borrow trouble. It's not going to be an issue, I assure you.
If she's out sick and nobody's there?
If she's out sick, Freddie, I'll be there, okay? If she has a long illness, if she has a one-day cold, you can wait till, it can wait for the next day. If she's on a prolonged illness, I will take over. Thank you, Freddie. Anything else? All right. Public arrest.
We have a motion.
A motion and a first.
second.
And a second. All in favor of the public records request policy?
I so moved that it be accepted.
And we had the second, right?
Yes, we have Darlene made the motion, Clayton seconded.
Seconded. All in favor, say aye.
Aye.
Opposed? Ayes have it.
All right, and we will have this information added to our website for all the public to see.
yeah, it's
Y'all heard that?
public information.
Okay,
isn't
great.
it?
All right. It's going to be added to the website, Freddie.
What is?
The public request policy,
The request policy will be added to the website.
along with the forms.
Concerned about is whether or not Greg's statement about the city manager is going to be formalized as opposed to just a verbal memory.
What I'm saying is it's public record, so we can, just like an agenda, you can leave them.
Right, it's just the,
At the time of the meeting.
right, yeah.
So he's wanting to ensure the board is planning to do that.
He don't need any insurance.
Y'all don't have-
We'll see to it you have it.
so much?
I mean, everything's
Did
an
you say
issue, y'all.
Nothing, Robert, it's okay, we're gonna move on, guys, let's keep
Let's
this on
go.
track.
Let's go.
You're gonna get it, Robert, we said it and we mean it. Okay, let's keep it moving, we have a hearing to get to. All right, number 5, auction business license approvals between board meetings. Okay, at the last meeting, we did the auctioneer's license. It was kind of an assumption on some part that we're going to do the business license as well, but we would just like to have it public record that Sandy can approve. You know, she'll call first. She's not going to do this on her own. I know you're going to have a question. I already see it. Could I just finish? Okay.
I move that any...
Make motion.
We what?
I'm ready for your motion.
Okay. I move that any
If they're
rest
licensed in another state.
Let me get through, Sandy. Any reciprocity state that reciprocities with Louisiana, any licensed business be granted a temporary operating license number until the board, between board meetings, provided bonds, et cetera, are met and file copies are on
All paperwork in
all
order.
paperwork concerned.
I second it.
We have a first and a second.
And I'm sorry,
I'm
can I
coming,
just
Lauren.
point out that the reason I wasn't meaning to interrupt you, the one that you guys passed for the auctioneers was that if they were licensed in any other state, they didn't have to necessarily be a reciprocal state with Louisiana. As long as they were licensed in any other state and they were coming in and they showed that they were in good standing, you guys would allow me to issue a
I want the business to be
temporary.
reciprocity with some other state of Louisiana. I do not want to open door on businesses.
Well, I'd like to look to explore that a little bit and have some colloquy on that particular things. There are some states, such as Mississippi, where you have to go through all kind of hoops if you want to be able to be an auctioneer there if you're licensed in Louisiana. And I can tell you that my company is trying to do that right now.
Thanks to Larry McCool.
Well, it may be, but I've been an auctioneer for many years. So I don't know that we should have such an open door policy where you're going to have every auctioneer from all over the state of Louisiana coming in here and opening up an auction exchange. I think that only hurts the people in Louisiana who have taken exams, pay taxes, and want to earn money.
It was a temporary, if it's between meetings and if all their paperwork's in order and everything, if it's something that would come up. It's not, she's not granting it. It was just if it's going to probably be approved
Right,
at the board meeting if everything's in order. If it gives permission to grant a temporary in between the two meetings.
Who says whether or not it's in order? And then that gives them the right to hold maybe a very large auction before the board meets, and they may not be qualified. How are you going to determine whether or not they're qualified? I think that's dangerous.
They have to be a licensed auctioneer.
Well, there are some of them that are licensed
It's just the
auctioneers,
business.
and, excuse me, that are licensed auctioneers, such as King Auction Company. They come in here and they hold auctions, and they say it's without limit and reserve, absolute auction. And right at the very end, right before you begin the auction, with 200 people there, they call up the auction because they feel like they can't get the minimum bid that they want to get in to satisfy their client. So I kind of have a problem with that. I think that anybody that wants to come into the state, even if they have all the requisites, I think we ought to look at it at a meeting, maybe have some discussion if in fact we want to have discussion. I want to know what their track record is if they're coming in, say, from Chicago with the public, before saying he has a temporary license, go hold 10 or 15 auctions before we meet again. I have a problem with that.
Okay.
I think it only hurts the current auctioneers that you have in Louisiana.
Hal?
And even before she said that, I was looking at putting in a buffer where if we didn't throw all that responsibility on Sandy.
No, she calls
but,
me, right?
If we had the board president and maybe Sandy, I don't think we have a lot of problems with this, but it would be a situation that if we were going to do something like this, we ought to have more than one person checking it.
Well,
absolutely.
That's what we were doing. She calls the chairman, and if I'm not available, she'd call the vice chairman. But she would get an okay before
How many of these do we usually have?
Only not just one. Just one.
It doesn't happen very often.
It's
It
rare.
just is kind of weird, though, about the last 3 meetings. We've had people who have even gone so far as calling the governor's office because they want a license, but this board has not yet met to issue a license. So they're calling their legislators, their senators, the governor's office, what can we do about getting a license? So that's what prompted the conversation among the board to see what could potentially be done to enhance people doing business in Louisiana and not making them wait 2 months for a board meeting.
Well,
I'm going to do it at the peril of the local auctioneers.
I'm gonna do this.
I'm going to get to you. I'm going to let the board do this and then get the motion ready, then I'll hear public comment.
There ain't gonna be no public comment, 'cause I'm fixing to pull the motion. Until this board does some more investigation, Sandy, I'm not gonna make a motion to do it. I'm gonna pull my motion.
So withdraw the motion.
Withdraw.
And the second has to approve the withdrawal.
The second, who seconded
I'd like
it?
to vote.
That was Greg.
Well, you're not withdrawing your... Okay, so
like
do
to
I need
vote.
somebody else to make a motion?
You're involved,
She-
he's
you become- I
involved,
think-
so, it's a temporary deal, and the whole board's gonna decide if there is if there is a problem, if y'all don't catch it, we'll catch it within 60 days, because we meet every 60 days anyway.
And what about, just to add to it, maybe, to have that safety net under us, even look at our attorney being involved, to check their background, make sure they're not unscrupulous or.
Yeah, that's a
you know,
good.
Yeah.
We could
That's
work
perfect.
this thing out if we tweak it a
Right.
little bit.
No, I understand her
that-
point.
Yeah, and we do want to be accommodating.
Yeah, I think if your motion would stand with maybe the three looking at it, Mr. Sims, you know, it could be something we could work through. We don't have a lot of these.
No.
And I don't think
It's
the baby
very
out with the
rare.
bathwater type deal.
Right.
But
Well, that's why I was trying to pull it to tweak it. You
Okay.
Get it like you want it, it's on
Well,
record.
you want to
I was trying
amend it?
Temporary usually means permanent.
No.
Once you give somebody a temporary license, they can go into court and get an injunction if you try to yank it for any reason. And that's a real problem, as your lawyer will tell you.
Yeah.
And then then they have for 2 or 3 years before you have a full-blown hearing. And I may have a problem with that as a lawyer, also as an auctioneer.
Do you want to amend it, Jim?
Why don't you let,
I mean, how do I amend it to, what do I amend it to?
why don't you let the
she
public,
can vote no.
why don't you let the public comment, and then we can decide.
Just let the original motion go and
Okay,
see where
well,
it hits. is all
All right, let me let let me get some public comment on this, then we'll go to
I
a
would
vote.
ask that you put all three in, Ms. Sims, in your motion. That would help me on voting.
Put what now?
Put not only our administrator, but our
All right,
chairman as well as the attorney.
add to the chairman, vice chairman, and attorney,
Chairman or vice chairman.
chairman or vice chairman.
And attorney. And attorney.
And attorney.
On temporary.
All right,
On
and you,
temporary license.
and you second that?
Yes.
Right, his amendment. Okay, Marvin, Mr. Henderson, you're first.
Time limit on this?
Yeah, as y'all all know, I have never been for
Time out.
Let's start. Good, 30 days?
Yes, sir.
Now,
How are you? I didn't get to say
Wait.
hi before.
Before you.
Hang on one second,
Hold on a
Marvin.
second. Also put in there that the maximum time at light permit, or light, I'm gonna call it a permit or a temporary
Temporary.
license, would be 60
Permit.
days,
Wait,
period.
can I say what we did at the last meeting was that the temporary license was only in effect until the next board meeting?
Right.
At 60 days.
Would work.
Okay.
Well, not necessarily if
If
they,
it's 30 days.
if they
the board
contact us
meeting.
30 days before the board meeting and they
Okay,
want a
whatever.
temporary
So just
license.
till the board meeting, okay.
You ready, Mr. Henderson?
Well, as I understand the motion right now, I have no objections whatsoever. Just want to make a statement that I do think there needs to be an instrument in place to allow this, because as all of you know, I've always stood against restricting other auctioneers from coming in or being restricted from going into other states. Because a lot of us do work internationally. And I'm not trying to I'm opposed to any legislation that would keep anybody else from coming into the state. I'm a free enterprise individual, and I think they ought to be allowed. I do think that your motion stands out now great. I've had this incident happen several times in the past. You don't always know 90 days in advance when you have a sale. And I've had a situation where I had to obtain a license in another state, and if I'd have just missed the meeting and then had to wait till the next meeting, it would eliminate the possibility. So I'm all in favor of having a license that would reciprocate, even if it's temporary. You still have your rights before the board, and I mean at that time. But I just want to make that statement that I think it ought to be an open market, because a lot of us auctioneers work nationwide. I'm not for restricting that. Thank you.
Thank you. Freddie, you're next.
I only have one question. Sandy mentioned that the previous with reciprocal auctions, whether they were reciprocity or non-reciprocity, was being approved as well. That's what you said.
I'm sorry, I don't understand what it is you're asking me that I said, so that's why I'm hesitating to answer.
You said prior to the auctioneer's license was for reciprocity and non-reciprocity auctioneers, correct?
They said if the person was licensed in another licensing state, if they were licensed in another state that had auctioneer licensing.
Not reciprocity.
Not necessarily reciprocal with us.
Okay. All right. So they stand within the same guidelines as those who are reciprocity, correct?
No, it's two different things. Two different things.
Well, that's why I was asking. That's why when she said, I wasn't clear on what she said, because I didn't hear that part in the last board meeting. That's why I was asking. My question would be then, with the businesses, are they in the same guidelines with the reciprocity for the auctioneers
The motion is that they must be from a reciprocal state.
only?
That's
Only.
the motion.
Only.
That's what I said. I want to just make sure. What
That's the
we're doing.
motion, right.
Okay, so I rest my case now.
Okay. Robert? Oh, okay. Sherry, I thought it was somebody back there, no? Okay. All right. I'm gonna roll call vote it.
All right, let me get to my sheet. All right, so the motion is to issue a temporary license to an auction business who is licensed in a reciprocal state. After the license is looked at by me, it will go to either the chairman or the vice chairman, followed by the attorney.
And the attorney.
And the attorney.
The attorney must have it.
And the temporary license will only be granted until which time the board can meet and officially vote.
Correct.
All right, Mr. Bordelon.
Wait, time out. We called the vote. Marvin, you have one quick comment before we vote?
I didn't understand that it's only reciprocal states, because a lot of states may not be reciprocal, but if they want to come in here and buy a license, let them have an auction.
That's how the motion was made.
I didn't understand that part of it. I just want to.
All the states that are have license are all reciprocal, aren't they?
Right.
No,
No,
no.
those are two different things.
I'm not gonna change the motion.
1 minute. You want to change it?
He said no.
No,
Okay.
I'm not gonna change
Freddie,
it.
you have one more quick question
I
before?
was saying, I thought he said he was gonna change it.
No,
No.
he's not changing. Okay, call the vote, please. Sandy?
Mr. Bordelon.
Yes.
Mr. Brister.
Yes.
Ms. Jacobs.
No.
Mr. Little.
Yes.
Mr. McMillan.
Yes.
Mr. Sims.
Yes.
Ms. Steinkamp.
Yes.
All right, 6-1.
6-1. Motion passes. Okay. Legislative Auditor's Report. Ms. Dow, would you please give that?
Okay, as many of you know at this point, there was a legislative auditor's compliance report prepared on the board. Pull this out, make sure I have it correct. The main issues with regard to the report involve the accrual of leave, both annual and sick, by the employee, as well as the merit raise as provided by law also for the employee. The basis, and yes, all employees for regard to the leave, not to the merit. The merit raise provision is an executive order, excuse me, issued by Governor Jindal. The leave provisions are on executive orders that go back to at least Mike Foster, as far as we could tell. With regard to this, the report came down, and I believe everyone has been provided a copy of the report and our answers.
The board members, yes.
Yes, including Ms. Jacobs. Did she get a
I believe
copy?
Ms. Jacobs was involved in that report, and then that email that went out on March the 5th.
Okay. So you're all aware of the issues with regard to that. The recommendations from the Legislative Auditor's Office was that we would recover any funds that were inappropriately paid by the board. At the time the report was actually released to the public, we had gotten a response from the Governor's Office with regard to leave that was contrary to what the Legislative Auditor had said. As a matter of fact, the General Counsel to Governor Jindal wrote an email to the Legislative Auditor telling their interpretation of the executive orders was incorrect, and that we were not covered on the executive orders with regard to leave, that was only within the distinct office of the governor and had nothing to do with the boards and commissions that had been moved into the office of the governor. The Legislative Auditor's Office chose not to list their interpretation of the of the executive order in their report, and issued the report without comment from the governor. Since that report was issued, the governor's office has issued a revised executive order which clarifies the issue of who is included or not included and what leave is available or not available. And to make a long story short, the new executive order, which is retroactive, as far back as they can go to 2008, and then they say that it shouldn't affect any interpretation prior to that, but that's what they feel the interpretation is that Sandy is eligible to accrue both annual and sick leave. She cannot accrue compensatory leave, which is not available to those who are executive directors of a board or commission. But other than that, then what she's been doing is perfectly fine, and she can continue to do so. With regard to the merit raise, that remains, that EO was not amended, but the opinion of the legislative auditor and the governor's office, as I understand it, is that it still applies to merit raises only, that the executive order specifically excludes any raises given for promotions or extra duty or other reasons which may be determined by the appointing authority. So as a result, if it's not a merit raise, it's not covered. And that's also in the interpretation from the governor in the direct email to the legislative auditor's office. So, upshot of this is the board has before it the legislative report with certain recommendations. We have a different opinion from the governor's office, which is now, at least part of which is now being codified into a revised executive order and is before the board as to what, if anything, they wish to do at this point with regard to those recommendations.
Well, why don't we just, the raise that was given at the last time to Ms. Edmonds, why don't we make that a merit raise?
No, we can't make it a merit raise.
Right. It wasn't a merit raise.
It was not a merit raise. As a matter of fact, the consensus, the interpretation by the legislative auditor's office is that merit raises are unconstitutional because they are giving money to someone for no apparent job.
But you can't give them an actual raise.
Yes.
Well, I thought that she got an actual raise. I mean, I think
she did.
You know, and I think that should continue.
Question on the legislative auditor's report. There were 5 findings in there.
Yes.
What does that do to the 5 findings that we were instructed to do?
Let me see if I can get the list, because I started to pull
I mean, the statute of limitations is sitting here counting on some of it.
I've got it right here, Anna, if you don't have it.
Yeah, the,
here's the recommendations page.
Thank you.
See this for housekeeping next time. We have something like that we're going to.
We need copies of this.
I'm sorry, I didn't because it's 25 pages long.
I don't care if it's
Okay,
125.
that's fine.
Okay.
You know, we want copies for the board members at least.
The
Somebody gave us
legislators
the
can vote
website.
themselves a big raise like they did the last time.
Didn't you?
What I'm getting at,
You're very
Anna,
confident, and I think you deserve everything you get.
Thank you.
Thank
You
you.
kept everybody informed.
well, what I'm getting at, Anna, statute of limitations involve some of those
Yes, you have
orders.
3 years from the date of leaving
We have orders to
recover.
do certain things in that legislative audit. And
Yes.
we faced with statute of limitations on part of it, correct?
That's correct.
So when does the statute of limitations run out?
3 years from the date any of our former employees left. For
So
example,
one is out with statute of limitations and one still in, is that correct?
well, Jim Steele is out because he left
I
more than 3
understand.
years ago. Ms. Wilkes had left in August of 2009, which is within the 3-year period.
So we,
But let me go through the list, and let's take each one, if that's what you want to do individually. Number 1 recommendation is executive orders are reviewed prior to any employment actions taken by either board. And I think that's no problem. I think we agreed to do that. As a matter of fact, we had reviewed it, but their interpretation was substantially different from the governor's office. Number 2, only eligible employees are allowed to accrue and use leave time. Now that we have it clarified that she can use annual leave and sick leave, then we have done so. Now, she cannot accrue compensatory leave because of her position. 3, employees maintain records of time and attendance. I believe that you are now keeping those, and had in the past, but there was some that just simply were not kept. So we're going to continue that because you cannot accrue leave without actually keeping records of when you were there or not there and which board you were working for. Supervisors review and approve employee attendance and leave records. I believe that the chairman, as her supervisor, should be doing that and filing on those.
And I am.
Okay, and the final one is the one you're referring to is the board seek repayment for amounts paid which may have violated state law and or executive orders. So those are the 5th one.
So-
The 5th one, again, we've now determined, at least within Jindal's from 2008 forward, which would include the date that Ms. Wilkes left.
I'm trying to be fair, that's why I want
yes.
this discussed.
Okay. That,
Because we're looking at a lot of money for her.
well, and this is the question. You know, as I understand it, the governor's office and division of administration, who actually defined this as far as statute is concerned, takes the position that there was never anything that barred us from having our employees accrued leave. And we've gotten that in writing from various agencies. But the legislative auditor has a completely different approach.
What's going to happen with this audit report?
It's filed and
That's what I'm getting at. Is it going to the Attorney General?
No. No, they did not, I believe.
They did not send it. They did not send it for review to the State Attorney General.
Let's see. Normally in these, they will make a statement in them that they are providing that to local DAs, Attorney Generals, or to other parties. And I do not believe.
Well, that's what I'm getting at. I don't want to wake up here one day and we got legal action against a former employee.
No, I don't think that's going to be an issue because the governor's office has now gotten involved and said.
Is he going to issue an amended report?
He already did.
He did.
He can't issue he can't amend the legislative auditor's report, but he amended his
I'm asking,
order.
is the legislative auditor going to issue an amended report?
As a matter of fact, the statement, as I understand it from the legislative auditor, was that they were not going to take the governor's interpretation of the governor's own order.
Well, then what do we do to be in
I don't think we have
compliance
a
with
choice.
legislative auditor?
We do. We are in the division with the governor's office. The governor determines what we do, and we've been told that we cannot do that.
Right. We have to follow the governor.
We cannot recover funds that were paid that were accrued legally.
The governor is saying that. Well, what do we do about the legislative auditor's orders?
You know, I've asked
the
both.
politics.
I'm not caring about the politics. I'm just saying, what do we do? It's
I don't know that we can
damn we do it, damn we don't. Now, which one is it?
We report to the governor, not to the legislature. They're a different branch of government.
All I want is Sherry Wilkes to have a fair shake.
Yeah.
Or this board do what it was instructed to do. One or the other. That's all I'm asking.
It was filed in there too, that Sherry and Cindy both
had to pay back money.
No, but they both questioned and were told in writing that I
understand
it was
that.
correct, and the governor is standing behind that is correct. The governor is saying they were both, Sherry was right, Cindy was right.
All I'm trying to do, Anna, is get this board by an ethics deal, that's all.
I'll see you Friday. I'm just going to let this discussion, then I'm going to let the board discuss, then I'll go to the public.
Right.
I don't think there's going to be an ethics issue because we've got it in writing from the governor's office that this was done correctly.
Okay.
So the auditors aren't requiring us to collect the money?
No, they said,
they made recommendation.
Right, that's just their recommendation. They're not saying you have to.
Is that what you're saying?
Could you please wait?
Well, usually when you have a legislative auditor recommendation, it must go to legal counsel. If it's a state board of any type, whether it's school board, police, jury, whatever it is, affairs funds, they call it misappropriated by inactions of a governing body, it must be recollected.
Right, but this one and I'm aware of that, and I've seen those which said we have provided this because there may be a criminal act involved. We provide this to the district attorney's office, the local.
All I'm trying to do is cover this board and cover these employees. That's all I'm trying to do. I'm trying to be fair and objective.
This was not sent to any criminal prosecution authority.
That's better news if I don't have to pay it back.
Got all that?
I got all that. Any board discussion before I go to the public? Anybody else? All right, Freddie, you were first. You want to?
I just want a copy of that revised salary.
It's on his website.
It's on the website?
It's on, yes, it was posted Friday afternoon.
On his website.
On the governor's website.
On the governor's website.
It's on the governor, okay.
The governor's website. It's on the governor's.
Executive Order BJ 2012-2.
On Jindal's website.
And 24 pages.
Correct. All right, any other comments?
You done?
You done, let's go. We got one more item.
He's done. Okay. All right. No action.
And I do have a copy if any of the board wants to see it. I did print it out this morning.
Yeah, I've got the
Okay. No action needed on that, right? Number 7, revision to board meeting rules, public comment. Well, in light of this meeting, most board members, as you stated earlier, don't do this with the debate back and forth, that they let the public comment for 3 minutes prior to each meeting on any item on the agenda. So do we have a motion?
Is that 3 minutes per subject, or?
No, 3 minutes.
3 minutes, period.
Period, on the agenda prior to each meeting.
The
But
statute
public-
says
the
that
statute
you
says
have to do it prior to any vote.
Prior to
And
the vote.
some agencies are saying that we're going to give you, this is the public comment time at the beginning on any item, and it's,
On the
full
agenda.
3 minutes on that item. On any item, excuse me. Get that
I
time.
can tell you today, with more organized than we've had in the past, I can tell you at our police jury meetings, if somebody wants to discuss more than one item, we let them. We don't make them get up in front of the meeting at the beginning and discuss 3 minutes to discuss 5 different items. It's been much more orderly today. Now, they get up, state their point, and move forward, but as far as the audience being in the middle of the debate, that's for us to debate the issues and then make a decision. But I surely don't want to get into any type of restriction where we're not letting the public have a say. I think the way today went all right with me.
Okay.
The only thing I say is, we want to give them ample time to discuss, like you're saying, and stuff like that. So I don't know if 3 minutes is enough for all the stuff right there, but I do know that's how some boards do it, because I've checked into it and stuff. So based on that, yeah, I'll make the motion that we accept
Want to do
that.
5 minutes? What do you want?
Well, how about 5?
You want to do 5?
Yeah, give them enough time.
What's your motion?
My motion is to let the public discuss anything that's on the agenda prior at the beginning of the meeting, so that we can move on.
For 5 minutes? For
Right.
5 minutes?
And I'll say 5 minutes, 3
And I
minutes.
second that.
I have a motion and a second. Any discussion? All right, Sherry, you're first. Could you, sorry, 1 second. Craig, would you hit it?
Oh, sorry.
I'm sorry.
Oftentimes, because the agenda is so generic, there is no way to know what points are going to be brought out until they are actually up for discussion. And so how do you know that you have a comment on a particular item until the discussion or the motions are made? Then and only then, when the motions are made, are you going to be able to sometimes form an opinion as to whether or not you want to speak on that topic or not. So I think that's being very restrictive. And if anything, if you think the meetings are too long because there's too many people discussing too many things, then limit the amount of time between for each person to be able to discuss it, but continue to allow them to be able to discuss each item as it comes up.
One at a time. Freddie, you want to be recognized? 1 second. Let us switch it over.
Okay.
I feel the
Go
same
ahead,
way,
Freddie.
that I think the board would be somewhat encouraging from the public if they don't give them opportunity to discuss the comments after each item. As Ms. Wilkes said, and I agree that most of the time we don't know what's going to be discussed. We don't know the board's viewpoint or which directions it's going to go. The other thing is that I would suggest that the board would allow the individual to go 3 minutes in his discussion as to what he's going to say or she's going to say, and then from there let the board discuss it or respond to that individual in their request. But to stop, and I've watched it about 7 times, where if someone's standing up talking and then the board goes into a discussion, that's not given a 3 minute time frame. And in fact, most time in the legislature, they do their 3 minutes right then and there, and then they yield the balance, and anybody can do that. So I'm thinking that the board should adopt those type of policies. And the board meetings will be fairly quick. Like I said, the only discussion that I have is when I ask
I've been here 2 hours and
questions.
15 minutes.
Something said.
No, are you finished?
You
No,
do?
I'm just listening to, I'm talking and someone else is talking.
And I asked him to please wait. That's what I was responding to.
Okay, because I couldn't hear. But that's what I feel that should take place, and I think the board should adopt that policy more than trying to get someone to stand up for 5 minutes when they don't know the board's direction or angle that they're going to go in. So I vehemently oppose that board take that position, that direction, and going with that.
I see you, right.
With that, that doesn't make sense to the general public. I think it's slightly funny.
I'd like to comment on that. Time to an auctioneer is the stock and trade, and most of us sitting on this, we're all auctioneers here with the exception of the attorney. I mean, we're volunteering.
2 members of the
You're not-
public.
You're not auctioneers?
2 public members of the public.
Okay. I mean, you know, but we're all volunteers to come here. I mean, and if you all have access to the agenda before the meeting, you know what the high points are going to be. Whereas if we open it up on everything that we're discussing, let everybody speak for 3 or 5 minutes, we're not going to get out of here. And time is very important to me, and I take these meetings very important. So, I mean, I think that those of you, it seems to me that repetitively, you only have a few of you all that are really commenting on the same issues that you could, if you have the agenda before the meeting, you all can get together and consolidate your thoughts on here and probably your arguments, and we can move the docket faster to make these meetings more meaningful and to bring out salient facts which have to be brought out.
Robert, you have a comment?
Yeah.
You got it, Greg. You okay?
Yeah. I am adamantly opposed to that particular proposition. I'll give a perfect example. You know, at the meeting in September of 2010, I asked to be recognized. I was told that it was not going to be, and if this thing goes through, that would be what happens again. All I wanted to say was there are professional charitable auctioneers for whom, if you put up on a website that we're going to offer these services for free, you're going to have a backlash from them, and I don't believe it's even legal. I was not afforded the opportunity to express those sentiments, and so I filed an open meeting law violation, and obviously the board agreed to settle it. I noticed the board did not put a list of auctioneers up on its website that would enable auctioneers to offer their, charitable auctioneer services for free. Had I been denied the opportunity, well, I was denied. I mean, I'd go back and rephrase it. Wasn't had. It's hypothetical. It happened. Very similar situation could happen here today. So you're going to say, you're not coming up. We let you speak at the beginning, and that's that. I think the board is going to, lose out on wisdom of audience members. And I don't think Mr. Henderson would appreciate. And you got to apply this to all of us. If he has something valuable to contribute, I think he has a right to get up here, and I want to hear him at the time that the item is being considered. And that would, I realize there are obviously some times that y'all get frustrated, and I can understand that. But I think the board as a whole loses out tremendously if during a discussion something comes up and an audience member decides that they've heard something that they feel they need to relevantly make a point about, to be denied that, I think is going to cause more problems than it creates. And number two, the point about we could all get together, well, just like the board doesn't always agree on things, and I've had many disagreements with Reverend Phillips. I know y'all may find it hard to believe, but, he and I, we don't always see eye to eye. We maintain a strong friendship, notwithstanding, and I'm not going to say, well, Freddie, I don't agree with that, so sit down. Don't go up there and express that. So it's not going to be a deal where we all get together and we're going to have the same, sentiments. We may agree with it, but there's certainly a lot of times I don't think, that's all I'm going to say.
Robert, it is common on a lot of boards that happens. This wouldn't be.
Well, I understand that, but my point is, if I feel I've been denied the opportunity as I was on September 20th, and you've done something that, had I had an opportunity to voice it, you could have saved yourself from doing it. Because I noticed nobody put that up on the website about offering free auctions, because you're going to get the backlash from those that specialize in that business. And I don't think the board can say, oh, we have a certain set of auctioneers over here that can offer this service for free.
All right, that's not on the agenda.
It was on September 20th.
Right.
The point is, I was denied the opportunity to speak. The board
I wasn't
voted.
The chairman at the time, Robert.
I'm not blaming you, Tessa. Don't get me. I'm not. I understand you weren't chairman. That the board went ahead and did it, voted to do it, but then didn't follow through. And I think it was very good that the board didn't follow through. Okay. Yes, I did send an email to the office after the fact saying that while the intentions are good here, the ramifications are going to be bad. Would have been better had the board not even made that vote, and I don't think it would have had I've been afforded the opportunity to speak.
Thank you.
You're welcome.
You have another comment, Freddie?
I had time, but all I want to say is,
you have time?
I had time.
You do. You have time.
You got over a minute.
Yeah. All I want to say is, if you're going to take that approach, I'm fair across the board to anyone.
You're what?
I'm fair across the board to anyone. If you're going to do it for anyone, do it for everyone.
Oh, of course, it's for everyone.
It's no exceptions to the rule at no time.
Absolutely. 5 minutes.
5 minutes, everybody.
Everybody.
But I'm just saying, let it be known, because when you don't do that, then I have a great problem with that, because.
Of course.
That's what I'm just saying.
So would I.
That's what I would like. because I know you won't do it and you won't uphold it all the time. It's gonna be exceptional, and that's what the problem's gonna be.
But that's why I
Can I
adjusted
make
it to 5 minutes instead of 3.
Well, let me make a suggestion. I mean, everybody knows, y'all all know who the board members are. My numbers are listed, even my home number is listed. If you all want to comment on something that's going to come before the board, I welcome you all to call me at home or call me at my office and tell me before it comes out what your comments are, so that at least we're prepared for it and you won't waste all of your 5 minutes when you get together at the meetings.
Right, and the auction board has an email address. I have the chairman at email address. You can email any questions.
Any more questions?
Okay, any more questions?
Don't we have a motion on the floor?
Yeah.
Yes.
Oh, Marvin, you have a comment? Come on.
Let me say first thing, and this is very unusual, y'all put it on the record, I agree with Robert.
Oh, shit.
You want to,
When I served on elected school boards,
time out, y'all, time out.
et cetera, et cetera. And I don't think it's possible at the beginning of a meeting, if you got 10 items or 15 items on the agenda, if I have pros or cons, to get up at the beginning of the meeting and voice everything that you have to say at 5 minutes at the beginning of the meeting. And I understand it's strictly sympathized with this board with all the ad-libbing and all the questions and everything, and I try to restrict that. But I mean,
You
if
do.
I'm here, and I'm not here to criticize this board. Y'all understand I'm here to support this board, and y'all all know that. But I really think that would be kind of a restraint to try to say, well, you know, whatever you got to say, you got 5 minutes at the beginning of the meeting, because you don't know what's going to come up. You don't know what your issues are going to be. You don't know what. I know I've been to board meetings, and I thought I had my mind made up when I was on boards that this is the way I'm going to do. But after discussion and after things from the public and et cetera, you have a change of mind. You understand you were on the wrong side. So I really, like I said, I agree with Rob. Thank you.
Larry?
Let's vote.
Let's vote.
Roll
I'm going to
call.
roll call vote it. We have a motion and a second. Read it back.
The
Sandy.
motion
Gosh.
is to allow members of the public to speak 5 minutes at the beginning of the meeting prior to the board
On
vote.
any agenda item.
I so move.
And it's
We already
seconded.
did.
Okay, so we just wanted to read it back. Let's roll call vote it. Call the
Yeah.
roll.
Mr. Bordelon?
Yes.
Mr. Brister?
Yes.
Ms. Jacobs?
Yes.
Mr. Little?
Yes.
Mr. McMillan?
No.
Mr. Sims?
Yes.
Ms. Steinkamp?
Yes.
6-1.
6-1. Motion passed. Okay, next meeting date is May 21st. We are going to adjourn
have a
for
break?
a hearing. We are going to take a 10 minutes. Good for everybody?
We need a-
15.
We need to
Maybe one
We need a
other.
motion to adjourn.
Oh, yeah,
before-
Motion to adjourn.
Just don't leave yet.
We're going to adjourn the meeting and resume back in 10 minutes. I need a second.
15 minutes.
15 minutes. We want to come back at 1:30 for the, we'll start the hearing at 1:30. We have a motion and a second. All in favor? Aye. Opposed? Ayes have it.